Good afternoon, everyone. First of all, we have to apologize for our late start of our 1 p.m. agenda due to the morning session running over on time. During the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make their presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. Any registered participants will be participating by audio. The committee members, we have three of us in person, Mr. Taylor on my left, Mr. Comeric on my right, and Laura Alderson participating remotely, and I am Michael Clark. Land acknowledgement. We acknowledge that the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed with multiple Mississauga and Chippewa bands. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is now called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. And we actually have 6 of those in a row this afternoon. Anyone who wishes to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because Committee of Adjustment and the TLAB, in the event of an appeal, will be sending notifications and appeal updates by email. If you don't agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body or, in some limited circumstances, to the Local Planning Appeal Tribunal. Appeal instructions are set out at the bottom of the decision of the committee. In the virtual setting, we proceed in order through the agenda. We'll start at item 19 and proceed accordingly. And where an application is uncontested, generally the applicant or agent will not be required to make a presentation unless the committee members request. The committees may ask questions of the applicant or agent and bring the matter into the committee for a decision. Uncontested applications where there are people here in opposition or with concerns or even in support, each speaker, including the applicant agent, is given a maximum period of 5 minutes to address the committee, and Mr. Comeric is watching the clock and will comment when you're reaching the 5-minute mark. When addressing the committee, please start off by clearly stating your name and address for the record, and please remember to confine your remarks to the matters outlined in the application. So the applicant or agent goes first, makes a presentation to the committee. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if it's being substantially revised in order to ensure that the revised application is accurate and all those entitled to notice of the application are informed of the changes. Then individuals, either in support or opposed to the application or with concerns, will be invited to speak. Committee members may ask questions of each speaker at the end of their presentations, and when all speakers other than the applicant agent have spoken, the applicant or agent is given an opportunity to rebut only those issues and respond to those questions that were raised by the neighbors, but not to introduce new evidence. That will then mark the end of the discussion, and the matter is then taken into the committee for a decision. Are there any declarations of interest of panel or staff on the items in the 1 o'clock time slot? None to declare. Thank you. We'll deal with deferral requests, Madam Secretary, as we go through the agenda. Okay. So in that case, we can proceed to the first application of the afternoon, number 19, 18 Engelsley Boulevard. How do you pronounce that? Okay. And On this application, we only have one speaker, the agent Raya Al Amin, and I'll just quickly, this application is concerning. This is to convert the basement into 3 additional dwelling units. There are 2 variances. We have revised plans, a cover letter. We have the rental demolition form completed. We have a tenant communication plan. And we have comments from planning. Planning is asking in event of approval that it be built substantially in accordance with the revised plans dated November 23rd. And transportation has provided a memo for information purposes with respect to the parking variance, advising that there's no room for further parking, but there's no condition proposed by transportation. And then last, we do not have an urban forestry on this application. So Mr. Alamin, welcome.
Hello. Good afternoon, committee members.
Okay.
Yeah,
so Ms. Alamin, I'm sorry about that.
It's okay.
So your client wants to build 3 apartments in the basement, and I guess they're undersized by the standards of what's required. Can you advise what that is in square feet?
We are proposing. Yeah, we are proposing 3 units in the basement.
Yes.
2 of them are 1-bedroom units. One of them is at 450 square foot. The second one is at 580 square foot. These are the 1-bedroom units. And there is a 2-bedroom unit at 890 square foot.
Okay, so it's sort of comparable to what you normally get at a downtown condo these days. But yeah, at the time, I guess 116 square meters was the minimum required area for a dwelling unit. But that was, what does 116 work out to in square feet? 1250. So there's lots of apartments in the city. We can take judicial notice that are less than that size. And community planning doesn't seem to have any problem with that. So we don't need a presentation. Let's see if committee members have any questions for you. I assume you're okay with the conditions of approval from community planning.
Yeah, we have been speaking to planning, and we are proposing a site improvement of a designated garbage enclosure and also a designated bike storage in the basement.
Right. So that is marked on the plans. So they want the plans tied to the approval.
Yeah. Correct.
Okay. I believe, let's see if committee members have any questions for you. Mr. Taylor has a question.
Yes, ma'am. You just listed off the area of each of the 3 apartments. One of them was quite large and 2 of them were 40 some odd square meters. The variance you're requesting says the proposed dwelling units will each have an area of 57.1 meters squared. That's inconsistent with what you just said, correct?
I think there's a bit of an error in the notice.
Should say average?
No, it's the minimum required lot area for each dwelling unit on a lot is 116 square meters. And they're going to have a lot area of 57.1 square meters for each of the dwelling units.
Oh, so it's not the dwelling.
It's not the dwelling size, it's the amount of lot area per unit.
Okay.
So we're going to have to fix the minutes and decision to reflect that clarification.
Okay, it says the subject property is comprised of a low-rise apartment building on a regular shaped lot with a total area of 1,600 square meters. So I guess if they then divide the square meters by 28 dwelling units as opposed to 25, the average unit size, the lot per unit, is that what we're, because they don't have any problem with that, but we just want to make sure it's clear as to what. So it's, if you take the total, I guess, 1,600 square meters and divide it by 28. Is that how it, what is that? What do you get when you do that? There you have it. If you take the total lot area, thanks for pointing that out, so it's the lot area, 1,600 square meters divided by 28 is 57.14. Okay. That's what it is. So it brings down the average, I guess, by the 3 units that Ms. Al-Amin has described. Okay, and she's advised she's okay with the proposed condition. So are there any other questions, or is someone ready to make a motion?
Just a question for staff, I think. There's a planning condition trying to tie to drawings dated November 23rd. The last, oh, here it is. Never mind, I've answered my own question. Thank you.
Okay. We're waiting for a motion. Yep.
Mr. Chair, I find the two variances requested satisfy the four tests under the Planning Act, and I move for approval, subject to the condition of the Planning Department.
Okay, thank you, Mr. Taylor. Seconder for that motion. Ms. Alderson, all in favor? Unanimously approved. Thank you, Ms. Alamin.
Thank you so much. Have a good afternoon.
Thank you. Okay, our next item is item number 20, 20 Ravenscrest Drive. This is an application for a new detached dwelling with an attached garage, and there is one variance to front yard setback. We have a covering letter. We have comments from Urban Forestry, Natural Feature, Ravines and Natural Feature Protection, and from TRCA. I didn't see a check off on the ravine, so maybe it doesn't apply, Madam Secretary Treasurer. And TRCA advises they have no objection, but that a permit is still required prior to the issuance of a building permit. And Urban Forestry. And that's all we have. The applicant is Mr. Eddie Perez. Welcome back, Mr. Perez.
Hello, good afternoon, Chairman and committee members.
Okay. I don't think we need, does anyone want a presentation, or we just have some questions for Mr. Perez? So what's with the ravines and natural feature protection? I see that the box isn't checked off. Does that mean that there is no condition?
Correct.
But there is TRCA. There, you just know you have to get a permit. Thank you for your covering letter, and let's see if committee members have any questions for you. And there is the only one variance. Okay, that's
Okay,
only one variance on a new build. That's quite
It's
impressive.
not bad. So given that I define the application to be minor and meeting the four tests, I would therefore like to move approval, subject to forestry condition number 3, which I believe is cash in lieu.
Give a seconder for Mr. Kamarik's motion. All in favor? Unanimous approval. Thank you.
Okay, thank you very much. Have a good evening.
Mr. Perez. Okay, item number 21 is 166 Kane Avenue. And this is an application to construct a new dwelling, detached dwelling with a detached garage in the rear yard. And there are 6 variances, and we have absolutely nothing other than the materials submitted with the application, the plans, and the survey. Agent is Marco Vieira, and nothing whatsoever, no communications from neighbors or from city departments. Mr. Vieira.
Good afternoon, Mr. Chair, members of the committee. Marco Vieira here as the agent.
Okay. You got 6 variances, you got a new build, and you have no comments from anyone.
No,
Sorry, you're right.
the scope of work,
Other than you're aware of the urban
it's a new house because it's deemed as a new house from zoning, but we're actually using the existing foundation and we're going up in line with the existing. That is why we're triggering some of the existing acts on the current dwelling.
So why do they call it a new detached dwelling as opposed to,
It-
a 2-story addition, a
because-
2nd-story addition, a deck, a porch, and it's basically the same thing. So why do they? It's just interesting to see why. they do
Because
that.
from zoning, as of zoning's definition, more than 50% of the first floor is being altered. So then it's deemed to be a new house. And that is why it says new.
Okay.
So even if you're keeping the foundation, it's still, there's no house to build.
Okay.
Correct.
Okay, and like I said, there's no issues on this with anyone. So
that-
let's see if committee members have any questions or if someone's ready to bring a motion.
That's where I had a question, but I think it's already been answered. Variance 2, with the side yard setback being so minimal, I was questioning that on a new build. So the north sideline, the north side setback is on the existing foundation?
Correct.
Okay, thanks.
Yeah, so it's right on the lot line.
Yeah, I mean, for
Oh,
a
you're
new
right.
build.
Yes, it
that's-
is.
So our new build, that looked like the one we had this morning.
Yeah,
Uh,
for
Then
a
why
new
would-
build, I find that problematic, and that's why I had a note for that.
yep.
Given that this was cited as a new.
Yeah.
Okay.
And the neighbor on that side has no issues. They aware of this application, I assume?
I believe my client has spoken to them. They haven't expressed any concerns. I know they've been cleaning up the lot in terms of its current condition versus what was there before. I think they're happy with the proposed change.
Okay. Okay, we're ready for a motion?
Okay, based on that, I would find the application to be meeting the 4 tests, and I would like to move approval subject to forestry conditions, condition 2 and condition 3.
Thank you, Mr. Kamarick. Seconded by Ms. Alderson. All in favor? Unanimously approved.
Thank you, Mr. Chair, members of the committee.
Thank you. Okay, next application is item number 22, 39 Lambton Avenue. Again, a detached dwelling with an attached garage. And they're going to maintain no, not attached. They're going to maintain sorry, it's a new detached dwelling, not with an attached garage, but with a secondary suite and to maintain the existing detached garage and shed. There are 10 variances. And there are 0 comments from community departments or area residents. We have nothing whatsoever, just like the last application. And the agent is Mike De Oliveira. Mr. De Oliveira, welcome.
Hi, yes, my name is Mike De Oliveira. I'm here representing 39 Lambton Avenue. I'm with Replacement Design, located at 911 Davenport Road. And just to make the committee clear, we do have neighbor support. We were just unable to get it in before the deadline.
Okay.
It is on the AIC website. We have signatures from 10 of the neighbors in the surrounding area, and I myself live 2 blocks down the road.
Okay.
So I'm happy to see this kind of development in my area. But I'll open it up for you to finish your comments, and if you have any
So
questions.
those 10 letters or whatever you have, it includes like the adjacent neighbors on either side, or they included, or the neighbor directly behind?
Yes, so our property is on a corner lot.
Okay,
So
okay,
the house that's actually beside us is not actually a house, it's an apartment building.
okay.
So we have signatures from the neighbors behind, to the side, across the street.
Oh,
So
yes,
we
yes.
have most of the people in the neighborhood.
Okay, I see that now. Okay. And no one has written in with concerns or in opposition. Committee members, any questions for Mr. De Oliveira, or is someone ready to bring a motion? And there is urban forestry conditions 1 and 2 on this one.
Mr. Chair, I find the requested variances meet the 4 tests under the Planning Act, and I move for approval subject to urban forestry conditions 1 and 2.
Thank you, Mr. Taylor. Seconded by Ms. Alderson. All in favor? You have your approval. Thank you.
Thank you very much. Have a good day.
Okay, now we get into the consent, the sever and associated minor variances with proposed new houses on the newly created lots. The first one is 23 A, B, and C, 52 Bellman Avenue. And let me just get this up. Mr. Romano is the agent on this. Let's just do a little summary of what this is. This is an application to obtain consent to sever the property into 2 undersized lots and to build A new detached dwelling with an attached garage requiring variances as outlined in applications B and C. And we have the site-specific zoning bylaw. We have 9 variances on each of the minor variance applications. We have a cover letter, revised plans, supporting material. We have the typical memos from engineering services and construction on consents. And I believe we have planning is recommending refusal of this application on the basis that 7.65 wide lots, I don't believe is compatible, notwithstanding a couple exceptions that they go through in their report. Mr. Romano.
Good afternoon.
Okay, and we also have opposition from 50A. I believe we had a lawyer write in a letter on behalf. Oh, right, this is a letter on behalf of the neighbor. We have a rather lengthy letter that sort of reads like a factum. I don't believe they've given us the cases that they refer to. I assume, Mr. Romano, you've seen this opposition letter.
I have seen the letter and I have spoken with that.
Okay, so perhaps
that
you can.
neighbor's lawyer.
Yeah, they haven't. Other than they're not a. Oh yes, sorry. Jennifer Croswell is here, representing 50A Bellman. So perhaps we should get a little presentation after my introduction, and then we'll hand it back to Ms. Croswell to make a presentation, and you'll have a chance to respond as well to that, as you know.
Thank you. So this is an application that's located on the west side of Bellman Avenue, and you'll see that on the air photograph. I have the number 52. It's about mid-block. It abuts the former school, and you'll see that Father Redmond Way is a street that is located to the west. Mm-hmm. And all of those gray or white squares and rectangles, etc., that abut my client's property to the rear are semi-detached dwellings. So those semi-detached dwellings are on lots that are of 6 meters to 9 meters in width, and those that abut the subject lands are 6 meters in width. And they are shown in photographs on the right-hand side and in the lower left-hand side of this exhibit. The left-hand side, lower left-hand side, you'll see that those dwellings, 2 stories above an integral garage, are quite visible from the rear yard of the subject site. And all of this is to say that the west side of Bellman Avenue is not like both the east side of Bellman Avenue and the rest of the neighborhood. The west side of Bellman Avenue, and this is information that's not in the planning report, because I would agree in the planning report that in the neighborhood, the majority are larger than 12 meters. Mm-hmm. But on the west side of Bellman, where the subject site is located, 15.3 meter frontage, and the existing lot area is the largest lot size on the west side of Bellman Avenue. 75% of the lots are less than 12 meters. 71% are 11 meters or smaller. And that is distinguishable from the balance of Bellman Avenue and the balance of the neighborhood. And that needs to be taken into account when considering that the proposal at 7.65 meters would be more closely associated with those lots that are on the west side of Bellman Avenue, as well as a semi-detached to the rear. And then being the largest lot on that block, this is not going to set an undesirable precedent for the rest of the neighborhood, just because of the distinguishing factors. You also see in the lower right, there's a front elevation. It is a low profile 2-story dwelling, integral garage and 1 level living above, with a hipped roof, slopes away from the side lot lines. And that is a slight departure to what one sees for most new dwellings in the neighborhood, which you'll see in the photographs to the right, which is integral garage and 2 levels of living above. And what we also see in terms of, so meaning that it's more low profile. And what we also see is that there is no lot coverage variance. A lot coverage variance is quite common for new construction in this neighborhood. However, in this case, it is a lot coverage of 27.9%, whereas 33% is permitted. So there is no variance, and that is also indicative of the fact that the lot area is quite capable of accommodating these dwellings. On the site plan, you will see that the buildings from front to back are remarkably similar in length to number 50A to the south, and that's on the bottom side of the site plan. The front wall of the dwelling starts where the front wall of the dwelling is today and lines up very well with the neighboring buildings, and the driveways do not interfere with the vegetation in the boulevard or elsewhere. So when we look at the official plan is looking to ensure that what is being proposed can respect and reinforce what exists. The official plan is not telling us to look at mimicking, replicating, or doing exactly the same as what exists. And clearly on the west side of Bellman, if the majority of lots, 75%, are less than the zoning requirement, and 71% or 11 meters or smaller, 12.5% are smaller than what's going to be proposed. Clearly, the proposal can respect and reinforce what currently exists today, and I would submit much better than the existing oversized 15.3 meter lot on that west side context. So the staff also have no concerns with any built form element. So I would submit that what is being proposed here does indeed respect and reinforce the neighborhood character with no unacceptable adverse impacts. And I would submit that the variances should be approved. The floor space index is less than what we see on many new builds that are in excess of 0.5 up to 0.88 times the area of the lot. Subject to any questions, sir?
Okay, I just have one. So just to clarify what you're saying in terms of this being opening up a floodgate, you're saying there aren't other 15 meter lots that could do this.
There is one other 15.3 meter wide lot on the same side of Bellman, but it is shorter in depth. It's closer to Palermo, and it is probably 15 meters shorter in depth, so it does not have the same lot area. And the lot area that's being proposed here is pretty close to what is permitted, 399 versus 465. So that exact same thing cannot be replicated on the west side of Bellman.
Okay, anyone have any questions for Mr. Romano before we go over to hear from the lawyer representing 50A? Okay, so with your permission, we'll hear from Jennifer Croswell.
Good afternoon. As you stated, my name is Jennifer Croswell of Croswell Law. I'm appearing today as counsel on behalf of Mr. and Mrs. Bellora. They're the owners of the house next door to the proposed demolition and 2 new builds. My clients are the owners of 50A Bellman Avenue, which is located to the south of the property in question. I'm appearing today on hearing numbers 23A, B, and C. My clients are of the same opinion as the city planner in terms of the new proposed severed lots and the 2 buildings. My clients, like the city planner, are also concerned that there's a lack of proper frontage and side yard setback will be out of keeping with the neighborhood and the official plan 4.1.5. The concerns of the city planner are also echoed by my clients in terms of the precedent of severing a lot into 2 smaller ones and what this will mean for the character of the neighborhood. Although the planner has brought up the lots that are located to the back of the property, these were a new set of builds, and the city planner themselves has differentiated these new builds from the character of the older neighborhood in which my clients reside and in which these variations are being requested. In addition to my clients' concerns about the character of the neighborhood, there would be practical issues for my clients if this severance and variation were allowed to go ahead. There's currently quite a significant drainage that occurs along the property line between the 2 houses. I've included my client's submissions, pictures of these drains. Currently, the soil at the side of the property is consistently wet, and there is a concern that if snow or water gets trapped between the houses, if they're close together especially, that there may be flooding in the basement There are also concerns that with two basements very close to each other, there will be the walls to catch the snow, and then there will be no soil in which the water can go. As I stated, even though there are the two drains, one at the front and one at the back, the soil at the side is always wet at this point. There's also a concern that my clients will experience a loss of sunlight and air circulation that they have been accustomed to. And these are some of the reasons that people move to this neighborhood. It is quite a different neighborhood than the new build that has been pointed out by the planner for the owner. My client's kitchen and upstairs living room are both facing where the new build would be. Having walls, especially it's going to be quite a tall building that's proposed, so close to my client's home will certainly impact my client's quality of life. Right now, my clients have 1.325 meters as the side yard setback on their property. If the new build would be allowed to go ahead as proposed, there will be less than 2 meters total between the two houses. Since the minimum is 1.2 from each side of the property line under the bylaws, and the new build is asking to be 0.9 meters from the southern edge of the property, they are asking for a side yard setback that is only 75% of the amount required by the bylaw. In addition, they have asked on the other side for side yard setbacks as small as 0.6, which is only half of the minimum required under the bylaw. My clients submit that that is not a minor variance. It's quite a significant difference when you're dealing with such small numbers. And a lack of proper side yard setback would have implications in terms of drainage, sunlight, airflow, snow piling, access for repairs and for cleaning the soffits and fascia. It is very much smaller than the bylaw allows. And in addition to that, the local character of the neighborhood is such that many houses have an even greater side yard setback than normal. And so this proposed tiny side yard setback would be even more out of line with the character of the neighborhood than it would be in some other neighborhoods. My clients ask that the consent to sever and the variances be refused. If the consent to sever and the variances are granted by the committee, despite the planner's concerns and my client's concerns, my clients would ask that the committee consider the conditions listed in their written submissions. In the case that the changes are allowed to go ahead, my clients would like to minimize the effect on them as much as possible. Given my client's serious health issues, including a stoma in his throat from a previous hospitalization due to diagnosed Legionnaire's disease, my clients have asked that if the proposed variances are allowed to go ahead, that the committee add some conditions to protect my client's fragile health.
Sorry,
I
you're
would
gonna have to
refer the-
wrap up. It's over 5 minutes, but just
Thank
please
you.
send
I
it.
would just refer the committee to the written submissions. Thank you.
Yeah, we've seen those. So I just have, one question dealing with your client's health considerations. So you mentioned something about
Yes.
testing the soil for, is that for Legionnaire's disease? Is that where he got it, or that it may be, I've never seen that as a requested condition for having testing of soil and groundwater, or some of the things you propose?
Yes. So my client is concerned that once someone has had Legionnaire's disease, if they are exposed to it again in the future, to Legionella is the name, there can be very severe consequences to that person's health. Because my client has been exposed in the past, and it is known, if you take a look on the CDC site, you can see that it does actually occur in groundwater. And my client's concern is that if there is groundwater that is contaminated with Legionella, if that becomes aerosolized or otherwise floats into the air, his stoma does not have the usual protections that our nose would have of the mucus and hair and everything to catch things that are coming in. And because he has been exposed to Legionella before, it would have very severe consequences for him.
Okay, because testing groundwater or soils for this is is it suspected that it's there because he had it, or that's where he got? Like, I just don't understand how. Normally you
They're
also
actually
zone for. Yeah, if you zone for the property, not for if that's a specific health concern. You're proposing that the applicant go through some testing of, I don't even know where they would go. I don't know if Mr. Romano can assist in this, if he has any experience or what his position is, but I'll just mention it seems a little unusual or of doing that. Can he reside while construction is going on, given his health condition, being exposed to dust and things of that nature due to, I assume their windows will be kept closed, but is that an issue, or it's just basically your request to have the soil tested for Legionella?
So basically, my client would like to reside, if possible, in the home. Obviously, if he's given any advice to the contrary by his specialists, he would listen to them. What he's asking the committee for, we do realize, is not a common thing. Obviously, he has a very unique health problem, one that you wouldn't see every day here at the committee. However, for him, it is very important. He was in the hospital for many months and was in the ICU on a ventilator, and he would like to avoid anything like that in the future. So his main concerns are mold, asbestos, or Legionella being present, as those would appear to be the most damaging things for him at this point in his recovery.
Okay, thank you, Ms. Croswell. Thank you for those
You're welcome.
suggestions. And let's see if committee members have any questions for you before we go back to Mr. Romano to respond to what you've had to say. Any questions for Ms. Croswell? Okay, Mr. Romano. The floor is yours.
Thank you once again, Mr. Chairman. If one looks at the property map on the west side of Bellman Avenue, one will see that municipal addresses are quite clearly indicating that there has been severance activity on the west side of Bellman Avenue.
Yeah, I was going to say,
that
given the A's and the B's and the A's, there's a few of them, 56A and B, and 50. I was going to ask if those were previous severances.
Yes, many years ago, and that includes Ms. Croswell's client. Ms. Croswell's client lives on a severed lot, 11 meters wide, and it is number 50A Bellman.
Okay, so it's 11.
So it may have one. Sorry.
So that's 11, not 7.6. So it was a 22-meter lot that was split to 11s, as opposed to
correct.
Yours, which
that
is 15 being split to 7.6.
Once again, sir, we are not looking to mimic exactly what is occurring in the neighborhood. We're looking to follow patterns. So the pattern on this side of Bellman is that the oversized lots have been severed to create more modest sized lots. And that would have included 50A Bellman, which on one side may have a larger side yard setback than it does on the other side. And that would have been in keeping with when those were built. And today, when new construction occurs in this neighborhood, the typical standard is 0.9 meters and 0.6 meters. And that is what's being followed for the subject lands. So there is no impact on the drains that exist. One is at the front in the city boulevard, and one is on the back on my client's property. So any drainage that 50A Bellman, Ms. Croswell's client, currently has into that drain in the back is not onto her client's property. It is onto my client's property. But having said that, and there is no alteration to where that drainage is occurring. And on the west side, on the south side of the subject lands, there is a driveway. And the driveway does not allow for the permeability of water. That driveway is closer to the side lot line than the proposed dwellings are going to be. So the dwellings will allow for more water penetration, which will alleviate the drainage, the constant wetness that Ms. Bellman or Ms. Croswell is referring to, at least as it relates to whatever is happening from number 52, the subject lands. In addition, the drainage must be kept on property and drained towards the front and the back pursuant to a grading and drainage plan that is to be approved by the building department as part of the building permit process. So that should alleviate the concerns with regards to drainage. And in terms of that setback, again, there is no eaves setback variance being proposed along the south. So the eaves is farther away from the side lot line than what is permitted, and that allows for the penetration of light. However, there is no sunlight that is going to go from the north to the south. The sun rises in the east and sets in the west, so then any shadow that is being cast is from Ms. Croswell's client onto the subject lands and not vice versa. So there is no effect on sunlight. Again, on the drainage on the subject lands, they will have weeping tiles, which is probably not existent today on the subject lands. And in terms of already mentioned the driveway, soil, sunlight, mold and asbestos. Those are items that are determined, as I mentioned to Ms. Croswell yesterday in a telephone conversation, by the building department when they have a demolition permit application before them. The city regulates demolition, and the demolition permit will require that, if any, is ameliorated and dealt with, so then it does not cause an impact on the subject lands nor on neighboring properties. As a result, as it relates to Legionella, I would agree, Mr. Chairman, that this is an unusual request that's being made. And I would submit that the significant number of brand new semi-detached dwellings that resulted in an excavation that is unprecedented in this neighborhood, immediately abutting Ms. Croswell and my client's properties, has led to no issues being raised regarding Legionella. So I don't believe that that is going to be a concern that's going to all of a sudden appear on the subject lands, given that it's the same soil structure. It's all being there at the same time. And those semis on Father Redmond Way have not caused any implications that I'm aware of that Ms. Croswell has raised. So with that, sir, I would submit that what the proposal is seeking to do is continue a pattern in this neighborhood on the west side of Bellman Avenue for the larger lots that are oversized relative to surrounding lands to have more modest size dwellings upon them. And I disagree with Ms. Croswell's statement that the planning staff have actually evaluated the lands to the west. Planning staff only commented on dwellings on Valermo. The planning report doesn't talk about the semis abutting the subject lands at all. So subject to any questions, sir, I hope I've addressed those concerns.
Okay, just want to point out something on procedural matter. I noticed that on the next page, there was another attendee on this application. That was Miss Jennifer Croswell's client, Mrs. Ballora. But she wouldn't be speaking in any event because she's being represented. We only have one speaker from each address. So she, I believe, is on the phone. Welcome. But we will not be hearing from Mrs. Ballora since she's represented by counsel. Any questions for Mr. Romano? Follow-up questions for Mr. Romano and or for that matter for Ms. Croswell?
Just a question for Mr. Romano. With regards to the abutting property at number 56, both 56A and 56B, are you aware of the frontage on those two properties?
Yes, sir, 9.6 meters.
Which is 2 meters less than what is being proposed on yours, correct?
They would be 2 meters larger.
Well, they're 2 meters larger, yeah.
Yes, yes.
I'm going to give this a go. I'm tending to side with planning on this, in that most of the other detached houses are on larger lots. There's perhaps one or two exceptions. Mr. Romano spoke about semis, and I think semis might be more appropriate for this site. I believe most of the variances are appropriate. My big concern is with the size of the lots that are going to be created. And therefore, I feel it's not appropriate and would like to move refusal.
Okay, motion for refusal, Mr. Kamarick. Do we have a seconder for that motion? Ms. Alderson? Okay, all in favor? I'm opposed, so the motion carries 3-1. The application is refused. Okay, thank you, Mr. Romano. Thank you, Ms. Croswell. Okay, our next application is again another consent to sever with associated variance applications for 2 new detached dwellings with detached garages to be built on either of the 2 newly created lots. We have on this application, in addition to stuff that was filed, we have draft R plans, we have plans on both sides, we have site-specific bylaw, applicant submissions on both of on the 2 variance applications. We actually have 4 submissions from the applicant. We have the typical engineering construction services memos and conditions in the event of a severance. And we have a planning report asking in the event of an approval that it be built substantially in accordance with the plans. They go through the history of the application, that the applicant made changes in response to planning's concerns, and they outline those changes. And there is some comment about they've made changes to mitigate the impact of the development, which they point out presents as a 3-story. So they've made some suggestions. The agent made those changes. And we also have 10 letters of support. We have urban forestry condition 2 and 3. And we have a letter of opposition from 4A. Yes, from 4A, Linus, who opposes variances 5 and 6 and doesn't say if his side yard is deficient or not. So the agent on this application is Leo Mastrandrea, and the neighbor at 4A has registered in concern to speak. Mr. Mastrandrea, welcome.
Yes, good afternoon, members of the committee. Before I start my presentation, we did revise our drawings to address the planning concerns. And in doing so, I noticed that variance number 7 should read front and rear, and it currently just reads the rear. And I was hoping that this is something that the committee would entertain to add the wording front and rear as opposed to just rear on both variances number
variance
7.
Variance 7.
Yes.
The height of all exterior main walls is 7 meters. The new dwelling will have rear exterior main wall height of 7.68. It should be rear and front, or front and rear.
Yes.
Madam Secretary Treasurer, do we have a notice issue here?
Yeah, we didn't give notice.
So are you saying we have to have notification, or it's, if we were to add that without notice, there is?
Because the front wall, based on the applicant's waiver, is 9.1 meters, so it's not the same amount.
Oh, it's a different amount.
Yeah.
So that's another, and it's worse than the other one. So in other words, if the front exterior main wall height was, let's say, 7.2, and this is 7.68, we could make the argument, well, it's actually, if they're approving the one at 7.68 and the one that's less, but if it's actually more, and you're saying it's a lot more at 9 something, then we gotta clearly have, if Mr. Mastrandrea, you heard, so if we have a notification issue, because the main wall height, if it was 7.68 or less, you'd have a better argument that we wouldn't have to re-notify?
Yes, that's what we're asking for, is the 7.68. We're not asking for the 9.1.
But that's what your waiver
So
states on file, submitted November 10th.
I know. Right, and we just noticed that if we don't add that, we're gonna have an issue with, once we go for building permits.
Sure, yeah.
So I thought that because everything else is at 7.68, including the soffit height,
But are your plans
and the
at
rear wall,
7.68?
yes.
So then why did you submit a waiver saying 9 meters?
We were gonna remove the one that said 9.1 meters. But I noticed that if we remove that, we're gonna have an issue with the front. So I thought if we could add it, if we could add the wording front and rear, then I could move forward with the presentation. If not, then we would have to defer it.
Yeah.
I think you need to defer it. Because your plans are the higher amount.
But if we were to add just the wording front and rear,
But it's a separate variance, right?
if you add the wording front and rear, I think that would address it.
But it's a
it's
separate
whatever,
section of the bylaw.
Yeah.
We would
Mr.
never have identified it in the one variance. They would be two separate
Fair enough.
variances.
Yeah, Leo, I think we
Fair
have no
enough.
choice but to have to, notwithstanding you got 10 letters of support, you only have, the one neighbor is here to know about it because 4A is in attendance here. So
Fair enough. I didn't want to waste.
I don't see any way around this. You're going to have a problem anyway down the road. It's unfortunate.
Okay, I didn't want to waste the time, so I just thought I'd bring that up first. And I think that in this case, then we should make a motion to, or to defer the application till we resolve this.
Yeah, in order to correct the notice to provide a variance for the front, the mirror image of number 7 at the same 7.68 or whatever you want to do when you come back.
Yes, it is a different variant. I did notice that it's A, I and not II, so.
Okay,
yes, then
let's
I,
just have to weigh in with the neighbor at 4A before we go to a motion because he's here. Or Young Feng Tu.
Yes, sir.
Hello.
Yes, good afternoon, dear sir. I
Good
am Yan Feng
afternoon.
Tu.
I don't know. You've been following along. It looks like we're not going to be able to deal with this application this afternoon because the
Okay.
applicant is missing a variance for the front wall height. So we're
Okay.
unable to, because there's improper notice, we're unable to proceed. So this matter is going to be adjourned, and you will be re-notified sometime, I guess, in the new year. This matter will be brought back on, and you will be
Okay.
notified. Okay?
Sure.
So
Yeah,
there's
thank
nothing
you.
we can do. Mr. Mastrandrea would like to proceed, but he can't because of the notice
Okay.
issue. Okay?
Yeah,
Committee
thank you.
members, thank you. Committee members, can we have a motion for a deferral?
And we don't have hearing dates set yet for next year, but if you talk to your case manager, then we'll see when we can schedule you, okay, Leo?
yes, okay, thank you.
But maybe in the meantime, talk to the neighbor.
Okay,
Thanks.
Okay, motion?
Mr. Chair, I'll move deferral to enable the addition of a additional variance.
Okay. Seconded for that motion. Ms. Alderson, all in favor. Matter has been deferred. Our next application is item 25, 101 10th Street. Again, it's another consent to sever with 2 new detached dwellings with detached garages. There's 2 covering letters. We have all the materials that were provided with the application, plans, cover letters, 2 cover letters. We have the memo from Engineering and Construction Services. Planning as requesting the event of an approval, it be built substantially in accordance. Again, they outline the history of the application and outline that the applicant has made changes based on planning's concerns, and they proceed to outline the changes for us in the memo. Yes, and this is when it says the changes are in order to mitigate the impact of the dwellings which present as 3-story dwellings, notwithstanding there are 2. And we have one speaker, Mirka Kuleza, the agent. Hello.
Hello, good afternoon. My name is Mirka Kulesza. I'm with Land Design Studio. We are the designers on the project, and I represent the owners.
Okay, we have your covering letters, so we know what the application is about. There is no one here in objection. I assume you're aware, and you're fine with the planning conditions and the general engineering conditions that go along with severances and consents, as well as urban forestry condition number 3. So I'll just see if committee members have any questions for
Payment
you.
of cash.
Sorry?
Yeah. I'm sorry, cash in lieu of for forestry condition. Yeah.
Okay. So unless you'd like to add anything, I guess we have the both your covering letter, which goes through the changes that you've made, as well as the planning memo, which goes through the changes that you made in order to address planning's concerns, and they are now satisfied. Okay.
I really don't have any comments, except for maybe one small remark. When I got the notice of COA hearing, I noticed that the wording using the word undersized lots, the 2 undersized lots will be created. Actually, they are not undersized. I straightened this out with Committee of Adjustments, so I believe we are on the same page now.
Yes, we're going to remove that from the minutes and the
Yes.
discussion.
Okay, so it's not,
I appreciate
these new lots are not undersized.
No, they are not.
I see, okay. So hold on, am I correct, on the new lot, you only have one variance on the?
Yes, there's just one variance, FSI.
Okay. Okay, let's see if committee members have any questions for you. Yeah, there's no letters of opposition or support for that matter that I have here. And we do have the planning memo, which advises the second one that they're satisfied based on those, there could be being built substantially in accordance with the architectural drawings. So committee members, any questions for the agent, or is someone ready to make a motion?
I'm just curious, ma'am, can you tell me what's the nature of the property immediately to the north? It looks well
The property, yes, it's actually a parking lot that belongs to a church. This property is located in mixed-use area. We have 2 churches, 1 school, commercial uses on Lakeshore, which is very close to 101 10th Street.
I see, thank you.
Thank you.
I believe the application is appropriate, meets the 4 tests. I would therefore like to move approval of the severance and the related conditions, subject to forestry condition number 3 for both, and subject to planning condition that it be constructed substantially in accordance with the drawings submitted September 25th, 2020.
Thank you, Mr. Kamarick. I have a seconder for Mr. Kamarick's motion. Ms. Alderson, all in favor? Unanimous approval.
Thank you very much. Have a good one.
Gleza. Okay, another consent and to sever and associated variance is number 26 A, B, and C, 96 Wesley Street. Consent to sever and build a single detached dwelling on each newly created lot. You have a planning report for information. There are 10 variances on each of the variance applications. Again, the applicant has made changes in response to planning's concerns. There's concern from the resident at 92B. Yeah, the concern was someone at 92, which is saying that the same owner owns 94. Why don't they do them at the same time to avoid disruption? Which I don't really consider like a concern letter, but so there really is nothing in concern. I guess that would be, I'm not sure if they're planning on doing that. We'll hear from the agent, but that certainly is not an appropriate condition in my mind. So this is a new detached dwelling with an attached garage on each lot and with 10 variances on each. And we have the typical engineering and construction and engineering memo. We have, okay, I saw an applicant request to be scheduled. I thought it said rescheduled, but no, we're going ahead. And the agent is Chris Marchese, and we have no other speakers on this application. And no letters of objection. Mr. Marchese?
Yes, I am here. Sorry, Sir Chair. I was just waiting for you to ask for me, but I am on the call here, and I am the planner from Design Plan Services, authorized to speak on behalf of the property owners of 96 Wesley Street for this application in front of you today.
Okay. So we have a planning report for information, which basically succinctly goes through the history of this application and indicates that they are supportive of that. They're giving us a report for information, but they don't recommend refusal or approval, but they advise they have no objection. There is no other speaker. So I don't think we need a presentation. Let's just see if committee members have any questions for you.
No problem.
Thank you, Mr. Marchese. Any questions for Mr. Marchese? Or is someone ready to make a motion? So yeah, just in terms of, I guess you've seen the letter of concern from 92B.
Yep.
And they're saying they believe that the applicant also owns the 94, and whether if they're going to do a similar variance application, he suggests it be done at the same time. I don't think he's concerned about your client's economy of scale, but his own disruption.
Yeah, I appreciate the comments through Third Chair. We were only 96 Wesley Street in the application that's in front of you. I can't speak honestly to the ownership of any other properties on Wesley for the owner of 96 Wesley Street.
Okay. Thank you for addressing that. So any questions for Mr. Marchese, or is someone ready to bring a motion?
Yeah, Mr. Chair, I find the application.
Just a point of clarification. Can I just clarify something?
Yes.
So community planning had no objection based on the revised drawings submitted on September 17th. And then I've got another date that's in the condition, which is September 25th. So I'm just wondering what the date really is. Is it September 17th or September 25th?
Yeah, there was 2 revisions done. They made one revision, went back to the planning staff, and a second revision was made to satisfy all their concerns. Planning staff has issued that on the report, and the application and the variances in front of you reflect all the changes at the request of planning staff, and their report also further advises the committee with the same direction.
And their report is
Okay, so the
for
date.
information. They're not asking for any conditions.
Okay. All right.
Someone ready to make a motion?
Mr. Chair, I find the consent to represent reasonable and appropriate development for this area, and I recommend or move approval of the consent, subject to the normal conditions of consent. I find the minor variances to be in keeping with the 4 tests under the Planning Act. The type of development on this very eclectic street, I think, is quite reasonable. There are semi-detached units on the street already. There's a row house development immediately across the street. So I move approval as well of the minor variances, subject to urban forestry conditions 1, 2, and 3, and conditions requested by engineering and construction services.
Thank you, Mr. Taylor. We have a seconder, Mr. Komarick. All in favor? You're in favor, Laura? Okay, it's unanimous.
Yeah, I just have one question. I've got a note that says transportation services has conditions, and I'm just wondering if they do.
Those are the engineering and construction services. It's in one report together.
It's all in one report. Okay, great. That's fine. Yes, all in favor.
So it's unanimous. Thank you, Mr. Marchese.
Perfect. Thank you, Sir Chair and fellow
Okay.
committee members. Have a great day.
Thank you. Okay, I believe this is our last consent to sever and variances of the afternoon. 84 North Drive. And this is an application to sever the property, frontage of 42.57 meters into two new lots, each with frontage of 21.27, and associated minor variances applications with respect to new detached dwellings with detached garages on each of the newly created lots. There are 16 variances on each of the minor variance applications. We have a couple of cover letters. We have a lot of information in the bookmark here, the notices, the draft R plans, plans, covering letters, canopy, arborist report with canopies, arborist reports on tree inventory. We have the standard engineering conditions. We have a planning report dated November 26, which recommends refusal of the application. We have objection from 89 North Drive. And registered to speak on behalf of the applicant is Dennis Wood as agent, as well as neighbors at 41 Hartfield Court and 17 Elstree Road. And that one, the Elstree Road is actually the president of the Humber Valley Village Residents Association. It's not a neighbor. I assume 41 Hartfield is a neighbor. Mr. Wood.
Good afternoon, sir.
Good afternoon.
And good afternoon to other members of the committee.
Okay, so we have an application to sever this property into two lots and build detached dwellings on each, and you have 16 variances, and you have a negative planning report and a neighbor in opposition. So the floor is yours.
Thank you very much. This application to divide the property has had a long history. Our client originally made application for 3 lots, and after consultation with engineering services, planning, TRCA, and the forestry folks, revised their application for 2 lots. The property is very heavily treed, as you can see. As a result, a natural heritage study was carried out by my client that lasted over 3 years. At the end of that process, you'll see that the TRCA are satisfied with the project, have requested a very considerable conveyance of the valley lands and a 10-meter buffer.
Sorry, the TRCA comments came in late. We're going to share them on the screen because they do include the conditions that would end up creating the dedication that is part of this application. So members, those are on the screen now. Okay. Sorry to interrupt you.
Thank you, and our client is satisfied with those those requests, and the a variance request, or sorry, the consent request has been modified very modestly to increase the amount of land that is to be conveyed to the Conservation Authority and to decrease the amount of the size or the area of the lots that that would be retained and conveyed. And that is addressed in the supplementary letter, which we supplied last week to the committee. So in terms of the public interest in regard to the natural heritage issues, the urban forestry people, as you will see, have signed off. They're satisfied with the rather extensive process of our client has gone through and the way in which the trees will be addressed. So having been able to successfully locate the 2 dwellings within this vegetated area, I want to turn to the I think the critical issue at hand, which is the lot frontage issue. The requirement that the request is for a 21.29 meter frontage for the lots. If the staff could pull up the map that we included with our application, you will see that the area that within which this property is located is, if you like, it's an island in the middle of a sea of zoning requirement for lot frontage, which is 15 meters and greater. But the size of the proposed lots is very consistent with the larger area. It's also consistent with the two lots that are located immediately to the, I get my east and west to the side, I'll put it that way, that are 15 meters in frontage. And I know it's hard to see that zoning map, but if it's increased in size, you'll see what I mean. The yellow area that's immediately across the street from our client's property is a 15-meter requirement for frontage, and the average of the median of the lots sizes in that community are about the same size as the frontage that our client is requesting. If you could turn just to one other, that's fine. Go one more. Sorry, I meant in my submission as opposed to the staff. You're able to pull back the applicant letter. While that's happening, what our client has been able to successfully do is to design the project in such a manner as to make the character of these two lots consistent entirely with the neighborhood. So this is a heavily treed area, and if you just slide through to the pictures, just keep going. Those are the areas that are conveyed to the municipality. There's attached to our letter. Now we're getting there. Keep going. We could keep going. Keep going. No, here we're getting there. Give one more slide, please. Right there. I don't know whether you could blow that up, but I had our client provide this to you so that you'd be able to see the before and after. The top is the proposed view from the street after the construction, and the above is the before and the below is the after. And you can see from the perspective of the character of the street, the character of the neighborhood, the difference is almost imperceptible. This is taken from across the street, more or less from the perspective of the objector, number 89. And that's largely retention of existing vegetation with some supplement for the to increase the density of the vegetation.
Yeah.
So what's really
Wood,
happened
sorry
is
if I
that
can just
there's
interrupt. Are those
Yeah.
evergreen trees? It's hard to see from here. It looks virtually the same, but what about in the wintertime? Are those leaves off those trees, or?
Yes,
are
well,
those-
you can see if you so you see below, we did think through that, and yes, there's a fair abundance of evergreens as well as deciduous.
Yeah.
So that has been taken into consideration.
Mhm.
The staff report, which is critical here, refers to policy 4.1.5 about reinforcing existing physical character, and that's why I'm showing you these pictures, because in my view, the existing physical character is of course maintained. But then the staff point at one policy that says it's to be maintained in the context of prevailing size and configuration of lots. Now, this doesn't say prevailing lot frontage. It says prevailing size and configuration. Now, these lots are configured in precisely the same manner as all of the abutting lots along North Street. So configuration is not an issue. Then we turn to the issue of size.
Sorry, Mr. Wood,
size
can you please
is
try to
area.
wrap up because you're at 7 minutes. We've let you go on a little longer, but.
Oh, well,
please try
I'm
to wrap
sorry.
up.
It's just very complicated.
I know.
Right. So it's if you look at just want to say deal with the size issue, that the lot size, I can tell you for the resultant parcels is greater than the minimum lot area required for those parcels. So they still retain as large, some people might call them quasi-estate lots. On the variances, it's their technical, we can talk about that. Then what you need to know is there's no overbuilding. The lot coverage permitted in the bylaw is 33%. The lot coverage for 84 North is 14.9, for 84B it's 15%. FSI permission is 0.45, 84 North is 0.26, and 84 North is 0.27. And the permitted GFA, of course, is less. So this is not an example of lot splitting in order to overbuild. It's a very subtle project that's been carefully, years in the planning, integrated and maintains the character of the area.
Okay, so
I would submit that it meets the tests of the Planning Act and also the requirements under Section 5124.
Okay, thank you,
Thank
Mr.
you.
Wood. So
Thank you for allowing me that little extra time.
that's okay. It's a complicated application, and you know, you get one for each severance, and then you get 15 minutes. But anyway, so I'm just looking at the planning report. So you would disagree? You say we're talking about lot patterning and lot size rather than lot frontage, because they point out, which is the thing when I reviewed the basic position, I believe they tried to come across is that one side of the street is 15 meter and one side is 30 meter. And you can sort of see from the lot planning that the estate size lots are on the even numbered of the street, and the odd numbered is the smaller lots. So you would disagree with that we should be bound by the 30-meter lot frontage on that side of the street and across at the 15 meter, so that you can't use the 15 meter because it's the other side of the street.
Well, I think what the staff are ignoring is that the average lot size across the street, when a lot frontage across the street is about 21 and plus. So the point I'm making is that the frontage of our client's proposal is more or less the same as the actual frontages across the street. In this sense, the 15-meter zoning bylaw, although we're above that, actually understates what is actually on the ground, but what is on the ground is consistent with what we're proposing. So
Okay.
that's sort of good, if I can put it that way.
Right. So I'm trying to see, I'm looking here that the planning is trying to say it's a different performance standard on each side of the street, which you typically see on ravine side lots, when one side of the streets has the beautiful ravine and the other side are typically smaller lots. One example close to where area part of the city I know is the Cedarville Ravine, Strathern and Heathdale.
Sure.
There's the ravine lots on the north side of Strathern, the south side of Heathdale, and then on the other side of the street, the lots are much smaller. Is that not what they're saying here? That it's a different.
Well,
you know,
I'm just they're not saying precisely. They're not precisely saying what you said, but what I'm saying is what the official plan now, after OPA 320, requires is that you will look at the prevailing character of the neighborhood. And that prevailing character is more than simply lot frontage. It's the whole look and feel of the neighborhood. Now, I'm saying the look and feel of this neighborhood, under OPA 320, they absolutely require you to consider the prevailing character on the opposite side of the street, which is the staff are ignoring. So if you do it properly under OPA 320, you look across the street and you see what the lot frontages are existing, and they're in almost precisely the size we're proposing. You look on the side that my client's property is, it's beside two lots that are 50 meters. There is only one other lot in this line of lots that has the qualities that my client's property has, which is lot area and frontage that might be a candidate for possible division in the future. Only one.
Okay.
So and they've gone the character issue. They've gone to great lengths to maintain character with that vegetative front. I challenge anyone to walk down that street and know what the frontage of those houses is.
Okay, thank you, Mr. Wood. Other questions for Mr. Wood before we move on to the two other speakers that are registered? Okay, the next speaker is Joanne Picard of 41 Hartfield Court. position.
Hi, Ms. Picard.
Hello?
Hi. You're a little bit muted. Can you maybe move a little bit closer to your microphone, please?
Yes, I'm sorry. Ann Anderson is going to speak for both of us.
Okay. So I'm going to put you on
And
mute
she's the
then.
next one.
Okay, I'll put you on mute then and unmute Ms. Anderson.
For the next up.
Okay, and Ms. Anderson is the president of the Humber Valley Village Residents Association.
That's
and I
correct.
just like to wear 41 Hartfield, although I don't know if it really matters. We also have the letter from members of from 89. There's a letter on file from the neighbor at 89, which is across the street on the. Okay, Ms. Anderson.
Yes, I'm here.
Good afternoon. So, why don't you let us know what the issues you have with this application? You're the president of the Humber Valley Village Residents Association, correct?
Yes, I am.
Okay. So the floor is yours.
Thank you. My address is 17 Elstree Road. Now, North Drive is just one street away from the border of our association on the north. The residents of North Drive shop at the same stores and attend the same schools and churches that our residents do. So what affects them affects us. And that's why we are making a deposition here today to oppose this proposal. First, Humber Valley Village Residents Association agrees wholeheartedly with planning's opposition to this application, precisely for the reasons outlined in the planning report. For the record, HVVRA does not contest minor variances at the Committee of Adjustment, even if we view them to be excessive or inappropriate. We do, however, challenge any proposed changes to zoning that we consider out of character with the neighborhood or inappropriate, as we see the case here. The planning report states on page 7 under zoning that 84 North Drive is subject to site-specific zoning bylaw 2940. The applicant wants to override the protective zoning and sever a single compliant lot into two substantially undersized lots. Our concern is that approval will establish a dangerous precedent and put site-specific zonings in our own neighborhood and in many others throughout the city at risk. Site-specific zoning is an invaluable planning tool that identifies unique pockets in the city that need protection and preservation. This zoning represents the city's long-term vision for the area and serves as a control mechanism to ensure a level of certainty and stability in the face of future development. The process to obtain this zoning is an arduous task, and we know this for a fact. In 2015, our association applied for site-specific zoning for the low-rise apartment neighborhood surrounding Humbertown Plaza. The planning study took 18 months. It involved community consultation meetings, I think about 18 working group meetings and frequent discussions with planning, but we got the site-specific zoning. And it's because the process to obtain the zoning can be so difficult, it troubles our association that bylaw 2940 would be rendered worthless if this application is approved. And even more so because planning opposes the application as it should. In 2018, HVVRA challenged a developer on the Kingsway in a case not unlike this one. He too wanted to sever his compliant lot into three, two of which would not conform to site-specific zoning bylaw 3314. Along with the city, we duked it out at the T-Lab for 6 days. The chair upheld the site-specific zoning and our position. The developer was only allowed to have two compliant lots. Our point is this: site-specific zoning is not awarded frivolously. It is only after careful review by planning, and it's planning that determines that protective zoning is desirable and warranted. And by the way, there's no expiration date on it. This is the city's long-term vision for the area, and in this case, for 84 North Drive. At 84 North Drive, neither of the proposed lots conform to site-specific zoning, nor do they conform to citywide bylaws. The existence of two undersized lots at 76 and 80 North Drive, which were grandfathered when the bylaw 2940 was enacted some 50 years ago, does not justify the creation of two additional undersized lots today, especially if it's at the expense of site-specific zoning bylaws. It's for these reasons that we ask the committee to accept planning's recommendation and ours and deny consent.
Okay, thank you very much, Ms. Anderson. And actually you make a very, very good point, which I don't think I've heard from many other people being on committee for a very long time. And that is when you compare a site-specific bylaw to a citywide bylaw, you can argue, well, there's a lot of exceptions because it's citywide and it's general. When it's site-specific, it's specific. So you made a very good point that I think you need more, or a site-specific bylaw should be upheld that much more closely than citywide bylaw, subject to making changes to that. Unless, of course, the site-specific zoning bylaw is, years out of date and just not in the current planning context or framework. So, okay, we don't have any other speakers, so we're going to go back to Mr. Wood for response to what you've had to say.
What I have to say about this is, firstly, the speaker who is speaking on behalf of a residents association that doesn't represent the people in this part of the community. That's number one. Number two.
Sorry, I want to clarify. You're saying that her association does not include these properties?
I think she said that. I'm just listening to that. She said that her boundary is not.
I thought she said she was just within the boundary. I thought she was just within the boundary.
No.
Oh, okay. In that case.
Well, she can. I think she said. She simply said what affects them affects us. So I thought that was consistent with what I had heard.
With your permission, could I just go back and clarify that with her? That is what you said. That it's outside because she's outside the area. And it's like Canada weighing in on a U.S. issue, which we don't want to do that. Okay, Ms. Anderson.
Yes.
And I'm sorry, maybe just my not comprehending or paying enough attention as I'm flipping papers. Did you say this area is the subject lot is within your mandate or just outside your mandate?
I've been muted here. Hello?
Hello, we can hear you. We hear your dog also, but we hear you.
I'm sorry, somebody came to the door and he's going
That's
crazy.
Okay, not a problem. We love dogs.
Yeah, I did say we are North Drive is one block away from the boundary of Humber Valley Village.
Oh, okay.
One block.
My mistake. Okay,
But
sorry. I just wanted to clarify that. You can go back to your dog. I just wasn't clear that was what you said. So it's my mistake. You said you're just outside the boundary, not within the boundary. Okay. Sorry about that. Sorry, Mr. Wood. Please proceed.
No, that's fine. That was an important clarification.
Yes, I
so my
agree.
point is that and what's obvious is there is no one here before you within the area that is relevant, the neighborhood that is relevant, who is objecting to this.
Well, we have a letter from 89.
In particular, all of the, well, I'm just trying to distinguish this. All of the people on the same side of North, which are the people with the larger lots,
right.
Who my client reached out to, I can tell you, to speak with them and determine whether they would have concerns. There are none of them here.
Yeah.
There's one objector across the street.
Correct.
And if you look carefully at that objection letter, he's raising concerns about tree preservation, noise, traffic, parking. And obviously we've carefully looked at all of those matters, and I'm not surprised that a person who enters this process will not necessarily be familiar with all of the care and detail that exists. Yep. So I'm saying there's one person who filed a letter. You're not hearing from that person. Doesn't make that concern any less relevant, but I do really think it's important that the people who will live with this, who understand the character of their immediate neighborhood, are saying this is okay. They're
Well,
not objecting.
they're not objecting.
Which makes
They're not saying
my
it's okay.
well, it's a color. But they're not here, and you know that if something is problematic, you will hear from neighbors.
That's correct. I agree with
And I think this is a tribute to the care my client's taken, both in the way the project has been planned for over, as I've said, two and a half years, and the outreach to their neighbors. And I'm just take you back to that photograph of the before and after. So whereas you will deal as you did with the previous applications, houses that are sitting straight in your face on the road, on the sidewalk, and size might matter in that. Lot size might matter in that case. In this case, lot size is given the nature of the community, the character of the area, and the way that this property will be developed, lot size will not be observable. And I take you back, the official plan, which applies to this property, says you're to look at maintaining the character of the neighborhood. The site-specific zoning matter, which was referred to, is interesting, but it's also legacy, and it is, though as far as I can tell, that bylaw is not listed as a prevailing bylaw under the new city harmonized bylaw 569/2013. It only shows up because that bylaw, the harmonized bylaw, is not fully enforced yet. So it's been superseded into the general bylaw. And I simply say to you, being a special bylaw does not vaccinate it against applications for variance of the nature that I'm bringing to you, and which have been carefully considered and meet the present OPA 320 adopted in the mid to, 2013, 14. It takes a number of years to get approved finally, but that's the up-to-date approach. And I'd urge on you that this lot, both the lots and the houses are consistent with the character of the neighborhood.
So, Mr. Wood, just a question. Do you know the date of that site-specific zoning bylaw? Because Ms. Anderson's comments and the fact that, like, if it's current and not 50 or, ancient, that is it not worthy of more protection than a citywide bylaw, which obviously people come with exceptions to all the time. But if you're saying that that's
my
superseded
understanding
by
is
the
that
new
sorry.
320, yeah, if it's superseded by that, I'm just curious as to how old that is and if that is in fact correct, that the site-specific bylaw is no longer.
By judging by the number, it's an Etobicoke bylaw. I've been in this practice for over 40 years, so
correct. That's why I'm asking.
I've lived through all of the joinings of the various, the merging that's gone on since the 70s. So it's an old Etobicoke bylaw, so we know that it predates the consolidation of municipalities into the city of Toronto. I'd like to give you an exact number. I have the planner in my office who works with me, and she has sent me an email saying it's a 1973 bylaw.
Okay. In any event,
so it's a legacy bylaw.
Okay, I'm just looking at the notice, so that's pursuant to the old bylaw. Okay. Okay, any further questions for Mr. Wood, or is someone ready to bring a motion? Okay, but no, the lot frontage requirement is still 30 meters on that side, correct? And on the other side.
Are you speaking to me?
Yes, that's still the performance standard in the new bylaw.
Yes, yes. There's no question about that. That it's that performance standard has been folded into the new bylaw. That wasn't my point. It
Right.
was that it's that notion of a site-specific zoning has been superseded by consolidation of the bylaws. But my point was not that there wasn't at one time site-specific zoning. It is that it is now part of the overall bylaw. It's subject to your jurisdiction with this under, the Planning Act, and more to the point, your considerations are subject to the most recent amendments to the City of Toronto official plan, which oblige you to look at the character of the existing area, both sides of the street. And it's the both sides of the street that was introduced by OPA 320, and it has only been, come into understanding, if I can put it, by the practice in the last couple of years.
Okay, thank you, Mr.
So
Wood.
that's all new.
Okay. Any questions, or is someone ready to make a motion?
Mr. Chair, just a couple of opening comments. Well, the official plan policies are made for interpretation. I know this area very well, and I can tell you that North Drive is a very clear and obvious delineator between two very distinct neighborhoods or communities, the north side and the south side, and it likely always will be. Secondly, I would like to say that this is a unique situation. This property, by my estimation, is about 55,000 square feet. So on the face of it, without even thinking about the details, you'd think, of course you can split it. Looking at the specifics of this situation, there are a number of lots on the distinct south side of North Drive that have less than 30 feet frontage. I don't see a problem with this proposal at the end of it all. And I would move approval of the consent and the variances subject to urban forestry conditions 2 and 3, the engineering and construction services conditions. Yes, that would be it.
Thank you, Mr. Taylor.
What about the TRCA conditions that we have for the dedication?
Oh, yes.
Oh, yeah.
Thank you. And the conditions required by TRCA.
Thank you. Those would be for the variances.
Okay, thank you, Mr. Taylor, for that motion. Do you have a seconder for that motion?
I'd like to second that motion. I think the treatment of the vegetation at street level is particularly good, and I think the neighbors should be very happy with that. So I'd like to second that motion.
Okay, thank you. Mr. Kamarick had his hand up, but we'll go with your comments. And I agree that I think that I was originally of the opinion that it was not worthy of support because of the different distinct delineation between the north and south side. But as Mr. Taylor, and based on his representation, notwithstanding that it's a different neighborhood, and I agree it is different, that 22-foot frontage and the size of the lots are still compatible, notwithstanding the lot is not cut. And Mr. Wood saying that more or less there aren't that many other opportunities on that side of the street for this to occur, which is always a fear of the community and the neighborhood that it's going to open the floodgates and you're suddenly not going to have that beautiful side of the street, which is a distinct neighborhood. But even with the division, it still is distinct, different from the other side of the street. So great, I think a very good result. And thank you, Mr. Wood, for your guidance of putting us through that. So all in favor?
Thank you.
Unanimous. Thank you. Unanimous approval.
Thank you.
Okay, we only have a next application as again, our last, I thought that was, but it's one more consent and severance. This one I have a note, confusing application. Just as my opening comment, it's item number 28. And the speaker on this application, we have the agent, Roland Rom Kolthoff, and as well as Speaker Christine Mercado from the Long Branch Neighborhood Association, the chair of the committee. So this is again a consent to sever and construct a pair of, in this case, semis, with a new semi on each side. There are 4 variants on each. We have applicant submission, cover letters, which outline the changes that have made. We have a copy of the Long Branch guidelines. Planning. Yeah, it looks like this came to committee on June 2020, and before that, January 2020. Planning is recommending refusal along with the councillor agrees with planning. But they do refer to an original application. Changes were made in June with 4 variances. And I believe then in September there were still concerns with the lot size. But I think the chronology is a little confusing, so perhaps the agent can go through that for us.
Sure. Hi, it's Roland Ron-Koltoff. Was that my cue to start
Yeah, that's your cue. So
presenting?
I'm a little confused
Okay.
with the chronology of this application when I went through it last night, but perhaps you can help
Well,
settle that confusion. And like I point out, there is, other than you, there's only the Long Branch Association commenting on this here to, I don't know if they're opposed or what their position is, but why don't you give us a presentation?
Right. With regard to the other 2 committee applications that were made, the last one was quite simply that the materials were not ready and we were not available to present, so we asked for deferral at that time.
That was on
The
July
one
20th, July 30th? Yeah.
I believe so, yeah. And then the
I
one
had a note
before, I
that
think,
I had noted it was deferred to consult and revise the plans to make it more in keeping. Maybe in
right.
September. Yeah.
Yes, and we did go back and look at our plans and try and make changes, but essentially the stumbling point with all of this is the width of the lot, and things appear to be all revolving around that. There are 4 variances being requested here.
Yes.
3 of them directly relate to the lot width, are derived from that, and the 4th is with regard to the height of the building that I can speak to. So we've been working on this project for over two years now to try and make something that would fit the character of the area. And we believe that we have done so through our work here, and which you can see in the presentation. The lot is currently just under 14 meters wide, and it's proposed to sever it into two parcels. Admittedly, it's 6.7 meters versus the 10.5 required by the bylaw. However, there are many, many lots in the immediate area, which I'll show you in a moment, which are also in the range of the size that we're proposing here. So that's the first variance requested. The second variance is the lot area, and that's again simply derived from the frontage. The lot depth is the same as the lot depth of all our neighbors up and down the street. So I guess maybe I can ask you to advance the slides so the point of this slide is just to direct your attention to immediately across the street from us, where the rendered building in this slide. There are 3-story townhomes directly across the street from us, and immediately north of us are 2 recent severances with a roughly a 6.8 meter lot width with 2 detached homes on it. Next slide. Again, a view down the street to show how we're trying to knit this building into the community. The bylaw does allow a 3-story height, and we are 3 stories. We are pushing back, though, in response to the Long Branch guidelines, the front of the building, to make sure that we appear as a 2-story volume when viewed from the street, and hoping that we can show that to you. Next slide. Again, a view closer up to show how the 3rd floor is well pushed back over 2 meters from the 2nd floor volume. Next slide. And that's a view from the street to show that we're aligning with our neighbor immediately to the north, which is a recently constructed building on also a substandard lot, if you want to phrase it as such. Next slide. Sorry, a lot of renderings here. Next slide. Just again to show the context. So this is the one where you can see that our lot depth is the same as all of our neighbors to the north and is typical of all the blocks surrounding us. So if our frontage is slightly below what the zoning bylaw requires, then our lot area, again, by definition, would be below that as well. But you can see in here that there are many three-story buildings and also many that have a narrower lot or as narrow a lot as we're proposing here in the surrounding. And most notably, again, directly across the street, our site is a little blue dot there. Directly across the street are 2 rows of townhomes. Next slide. So these are just typical homes in the area, roughly the same width and size and scale as what we're proposing. Next slide. This is an analysis of the Long Branch guidelines applied over our dwelling, over our proposal, and our neighbors immediately north and south to show how the roof line can vary, and we can emphasize the front facade of the building, which is in keeping with the 2-story height of the street. Next slide. So the summary of the variances. So we did originally apply for PPR and subsequently went back and revised the design and the drawings to reduce the number of variances to just the 4 that you see before you here. Next slide. So we reduced the floor to make it 4 feet from the adjacent grade. Next slide. And we took away some balconies on the 3rd floor. Next slide. We adjusted the driveway width. Next slide. This also helps preserve the existing street tree. We provided the appropriate amount of softscape in front. Next slide. So this is the GFA, which again falls out of the lot area. So we're showing just at the 3 floors above, net a total GFA at an FSI of 0.77, I believe it is. Yes, 0.77. Next slide. And the height. So although we are the zoning plans examiner has said that they consider the exterior main wall to be 10.3 meters high. We submit that when viewed from the street, our main wall is actually 7.85 meters high, which would be compliant with the
Mr.
bylaw.
Kolthoff, can you try to wrap up because you're at 6 minutes? Thanks.
Oh, I apologize. Okay, so that was the height. Let's go next slide. So this is with regard to the lot area. So there are lots in the neighborhood which are smaller than what we're proposing already. Next slide. And similarly, there are lots in the neighborhood which are narrower than ours. Again, most directly opposite us, the townhouses across the street are narrower than what we're proposing here. And there are semi-detached dwellings in the neighborhood, which is what we're proposing here, semi-detached, not fully detached homes on the site that have the same lot width. And I think I can wrap it up there. I think the rest of it's self-explanatory. Oh, and there's 13 letters of support. So the owner has gone out to talk to all his neighbors and has gotten support. We haven't got any, or at least I have not heard of any opposition from immediate neighbors to this site.
So can you deal with I guess we have the negative planning report. They go through the history. You at one point had 9 variances. They were opposed. Now you only have 4 variances and they're still opposed. And then they say from the last time in July, there hasn't been any changes when it was deferred for changes. Because there was first a report dated January. January, you had 9 variances and they recommend refusal. You made changes. You went up to 4 variances. They wrote a report June 22nd. They were still against it. And I believe at the hearing on July 30th, which would just be a month after this report, it was then adjourned in order to consult with planning and revise the plans to be more in keeping. That was when you went from 4, and those have not changed, correct?
Well, they're not really. Oh, sorry. Were you not
No,
finished?
those 4 variances, have any of them been reduced? Because they said, well, there's no change, so our memo still stands. That's what planning
Yeah,
is.
Their
those
comment
very
says the consent. I think they're.
No, but first they objected when you had 9 variances, and they said refuse. You then came back, and you have 4 variances now, and you've gone through that, and they're still opposed. That was the June 22nd report, which they've now said that report still stands because there were no changes made subsequent to the July 30th deferral.
We did change the roof line of the building subsequent to the application, but the ones we really can't change are the actual lot dimensions. Like we're splitting the lot in half, so the lot width is 6.7, and that seems to be the
No, I understand
line
that, but I'm
that
just
staff
saying,
could not cross.
but all I'm saying is at the July 30th, my notes say the deferral then, you're saying it's something because we didn't have something was wrong, but it says, at least my notes said, the minutes said it was to consult and revise plans to be more in keeping. But now
Okay,
you're
well,
saying that those.
I was not able to be
Yeah,
present
okay,
at
so you're
that
saying you weren't
meeting.
able to make
I
any
do know that
changes.
and we did try and make minor changes to the design. Again, it was the roof line to try and reduce the visual impact of the building on the street. We could not really change the real sort of meat of the issue here, which is the lot width and the lot area.
I agree. And other than that, all you had was the gross floor area and the height.
Yeah.
So.
Yeah.
Okay. Any further questions? We'll go on to Christine Mercado from the Long Branch Neighborhood Association and see what her concerns are. And you'll have a chance to respond, sir.
Hello, Mr. Chair and committee members. This is Christine Mercado, and I'm the chair of the Long Branch Neighborhood Association. If I could ask staff to pull up my supporting material for this application. And nope, that's not it. Okay, and it would be, there we go, yes. So as you can see, when you look at on this particular page, this is a location of 1330th Street, and it is located in an RM zone. And so the LENA does have concerns about the lot size, because what's permitted on this lot is a single family dwelling of 2,066 square feet, which is a marketable home. And what is being proposed is over twice that size. If you go to the next page, please. The next one, please. Okay, we have outlined what is permitted, and I'm pretty sure that the committee is aware of this, but it's also located to next door to a zoning, which is a townhouse zoning, which is across the street. And this is where the lot density, the lot area is a problem, because the comparables that the applicant is pointing out, these are the lot widths that he thinks that are appropriate. And the thing is that you can't, to be compliant with OP 4.5.1, you're supposed to be doing comparables within the geographic neighborhood. And the first of all, you need to look at zoning. And so he's actually looking at comparables that are in a townhouse zoning, which is probably what the stumbling block is for planning, because I know that it was for the LBNA. So if you look at the west side and look at the geographic neighborhood on 30th Street, it is in a state of renewal. All the datum lines, they're in various stages, but all the datum lines are being observed. So the front doors are at the same height. They present it as a solid 1 and 2 stories, not the perceived third story, which is being proposed. And there is one semi on that block, and it is on a smaller lot, but that semi is proportionately smaller. And it does fit with the datum lines that are already established on this block. So this block is established. It's not, so really what they're creating is an outlier that they're trying to compare with the RTs that are across the street. When you look at the true comparables, which would be on the next block over, which would be 32nd Street, there are semis on this property as well. But those properties, if you look at the unsevered width, are over 15 meters. So these aren't comparables to what the applicant is proposing. So I do acknowledge that he does have support on neighbors that are in the neighborhood, and I applaud him for that. However, I do not think that support would be withdrawn from this proposal if what was permitted, which is a single family dwelling, was also proposed, and something that is more an appropriate density for what is permitted. So in closing, we do think that the root of this problem is that they are creating an outlier on this side of the street and in this geographic zone. And it's our opinion that this application is contrary to OP 4.1.5, Policy A, which is prevailing size and configuration of lots, C, which is prevailing heights, massing scale, density, and dwelling type. It is single-family dwelling in this neighborhood, even though it is mixed. And in G, prevailing pattern of rear and side yard setbacks and landscaped open space. Thank you.
Thank you, Ms. Mercado. Any questions for Ms. Mercado before we go back to the agent for a reply? Okay. Mr. Kolthoff?
Well, I think,
So
I think
first of all, you've
the,
seen, I did acknowledge you have 13 letters of support on the, you've read the Long Branch Association's objection letter with their productions, and you've heard from Ms. Mercado. So please respond to the concerns she says. She says it's not worthy of support, along with planning and the council.
our position is that the building is reflective of the character of the neighborhood as a whole, be it one block or the other side of 30th Street. I would direct the committee to look at the pages 7, 18, and 19 in our presentation, which clearly show there's a mixture of 3-story dwellings in the wider neighborhood around us on the same block that we're on the block opposite us, to the north, south of us. In fact, there's a very large development in the schoolyard, but that's not in character with the neighborhood at all, of 5 stories, that larger block. So that's page 7. Thank you for bringing that up. So I think that shows that we're in character with the neighborhood, both in terms of the relative lot width, be it that we're slightly off from our neighbor's 6.8 and we're 6.7, but that's pretty close. And then if you look at pages 18 and 19, you can see analysis of the lot width. So we're not only talking about the townhomes immediately to the east of us, but it is important to point out they are part of the character of the area. They are part of the built context in which this new development is going forward. But there are lots in and around those, which are also in the same range or smaller than ours. And then on page 19, just a simple comparison between the semi up the street, which again is just a few inches wider than we are proposing here. So I submit that we are within context, and we have paid attention to the guidelines and analyzed them and tried to mass this building as respectfully as possible to maintain the street character. I think we've done so.
Okay, thank you, Mr. Kolthoff. Any further questions for Mr. Kolthoff or Christine Mercado, or is someone ready to make a motion?
Mr. Chair, I see this as a great example of infill. I look at the lot pattern in the area, and this jumps out to me as a natural severance. It's the largest lot on the street, on that side of the street, or the other side, for that matter. I like the semi-detached concept because it helps us avoid the issues that are very familiar to us about inadequate yards. This application does not require any yard variances. So I approve of the severance, subject to normal conditions for consent, and the minor variance as well, subject to urban forestry conditions 1, 2, and 3, and the conditions requested by engineering and construction services.
Thank you, Mr. Taylor. Do we have a seconder for Mr. Taylor's motion?
I'll second that. I had a slight concern. I think the massing and the size of the lots is appropriate. I had a slight concern with regards to the height, but I believe that is mitigated to some degree with the setbacks. I'll second that.
Thank you, Mr. Kamerick. All in favor? Laura, are you in favor or opposed? Opposed? We couldn't hear you.
Yeah, I think so, yeah.
Okay, good thing we can read lips. Okay, so the motion
Sorry.
carries. The motion carries 3 to
Opposed.
1. The application is approved. That concludes the 1 p.m. Time slot, and we're now going to move to the 3 o'clock time slot. Should we take a 5-minute break? Yeah, you have to sign check, and I note that I guess I have to read the opening remarks. I note that we have 1, 2, 4, 3, 4, 5, 6 applications. The first 2 may be deferred.
Yep.
So we're only going to have, I guess I still have to do the opening remarks, but we can do that when we get back. So we'll stand adjourned till 4:20.
Sure.
Okay. Or 4:15. Well, he has to do the sound checks. Okay.
Hi, Mr. Flynn.
Yes.
Hi, just doing a sound check. So I'm going to put you back on
sorry?
mute. I'm just doing a sound check. So I'm going to put
okay.
you back on mute.
Thank you.
Sorry, Mr. Flynn. Sorry, oh no, he did. Sorry, he called me. He called me after I wrote it. Hi, Mr. Walchuk.
Hi, yes, present.
Hi, you're the owner for 32 Poplar, right?
You've got that correct, yes.
Okay, I'm going to put you back on mute.
Thank you.
Hi, Danuta.
Yes, we're here.
Okay, I'm going to put you back on mute.
Thank you.
Are we on now?
No, they were just doing a test.
Sorry, are you going to be presenting the application, or is Danuta going to be presenting the application? Or sorry, speaking on behalf of 31 Groverdale.
Yes.
So Danuta, you'll be speaking on behalf.
I'll be speaking on behalf of 31 Groverdale.
Okay, thank you.
Thank you.
Hi, Mr. Barrett.
Good afternoon.
Hi, just a reminder that you are required to pre-register. You haven't pre-registered again for this hearing, so yeah.
Apologies.
Yeah, so we urge you to follow the instructions outlined on the public hearing notice and send us an email that you will be the one presenting the application when it comes up. Okay?
Yeah, you got it. Sorry.
Yep. Andre Grisolia.
Present.
Hi. Same thing for you, Mr. Grisolia. We do encourage that you send an email as outlined on the public hearing notice, letting us know that you will be the one outlining the application.
And that would go to the person that sent the email, I guess, or to the email that's on on that particular one that was sent to me regarding the hearing.
So you received an email from myself with instructions on how to connect because you were the applicant on file. But if you take a look at the public hearing notice, it states clearly that you are required to pre-register. So you would send the general mailbox an email that says you will be the agent representing the application. So like in Etobicoke, it would be the Etobicoke one, but each district has their own general email box.
Okay, so I just do so in that way, right?
Yep.
Yeah.
Okay, I'm going to put you back on mute.
Okay, thank you.
Hi, Stephen Lindy. Mr. Lindy. Stephen Lindy. Hi, Franco.
Hi, good afternoon.
Hi. Your sounds seems to be working well, so I'm gonna put you back on mute, okay?
Okay, thanks.
Lana Sturmack.
I'm here.
Hi, thank you. Your sound seems to be working. I'm gonna put you back on mute, okay?
Thank you.
Ron MacArthur.
Present. Good afternoon.
Good afternoon. Your sound seems to be working, so I'm gonna put you back on mute, okay?
Sounds good.
Now I'm gonna go back to Stephen Lindy. Hi, Mr. Lindy. Stephen Lindy. Okay. We will come back to Mr. Lindy. Okay, so for everyone that's still on the WebEx meeting, it's now 4:08. 4:09. We're gonna come back in about 11 minutes to start. So hang tight, and we do appreciate your patience as the first couple of sessions ran a little bit late. Hi, Mr. Lindy.
Yeah, I'm so sorry. I couldn't do anything.
I think I'm hearing a bit of an echo. Actually, so if you can
I
just
was on both the camera and the phone, so I don't know which one's working better.
let me see. Hold on, I'm gonna mute this one and I'm gonna unmute your phone, okay? Mr. Lindy?
I'm here still.
Hi, yeah. So the phone seems to be working better. There isn't
Okay, let's use the phone then.
yeah, there doesn't seem
Thank
to
you
be
very
an
much.
echo, but I don't know if you heard my little preamble to the other applicants. You are required to pre-register. So in future, yeah, so in future, if you come to committee again down the road or whatever, just send us an email outlining that you will be the one outlining or presenting the application, just because the applicant isn't always the authorized agent. So in order to minimize confusion, we do require all agents pre-register.
Is this Adam?
Yep.
Or Paul?
Adam.
Okay, so I'm sending that now. I'm sorry.
No, well, you don't have to do it now because we already have you as the agent, but like in future.
Thank you very much.
No problem. I'm gonna put you back on mute, okay?
Thank you very much.
Okay, good afternoon. We're now just about to start the 3 o'clock agenda. We have 6 items. And during the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make their presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. Land acknowledgement. We acknowledge that the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with sections 45 and 53 of the Planning Act, 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. Anyone who wishes to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because Committee of Adjustment and the TLAB will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances, to the Local Planning Appeal Tribunal, and appeal instructions are set out in the bottom of the decision of the committee. Okay, we'll go in order, starting at item number 29. When you address the committee, please start off by clearly stating your name and address, and please remember to confine your remarks to the matters outlined in the application. Each speaker, including the application, is given a maximum of 5 minutes to address the committee, and we will comment and advise you when you are at around the 5-minute mark. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if it's being substantially revised in order to ensure that the revised application is both accurate and that all those entitled to notice of the application are informed of the changes. Okay. Any conflicts of interest or declarations of interest by panel or staff on the matters at the 3 o'clock agenda to declare? None to declare? Okay. So we'll start with item number 29, 47 Burnhamthorpe Park Boulevard. And we have registered for this application only one speaker, Michael Flynn, the agent, but I believe there is going to be a request to defer, so since there's no one else here and we're only Mr. Flynn, I don't have to summarize what the application is about. Mr. Flynn.
Yes, sir.
We're also actually, this is the one that the staff report for this application was put in with item number 11, so I don't know if we can scroll down to they're recommending refusal of variance number 1. But in any event, Mr. Flynn, I believe you're looking for a deferral?
Actually, staff is looking for a deferral. The notice is incorrect, and this sign was incorrect. Both state that it's an addition to the east side, and it's not. It's an addition to the west side.
Okay. So,
needless to say, it's a conflict with what we want.
Right. So basically, I guess it has to be adjourned in order to provide proper notice.
Correct.
So we have no choice. Okay, committee members, so can I have a motion to defer this application?
I can put forward a motion to defer the application.
Okay, Mr. Kamara?
So the purpose is correct, the variance is wrong.
Oh, okay.
Sorry, yes, to correct the variances that are wrong.
No. from the west
It's
side
actually
lot line. That should say east lot line in variance number 1.
Variance number 1.
Yeah, will be altered, located 0.08 from the east side lot line. Okay. Okay, the motion from Ms.
Not
Alderson.
properly identified.
Okay, seconder for that motion? Mr. Comer. All in favor? Okay, matters adjourned. We'll see you again. Happy New Year, Mr. Flynn.
And the same to you, sir, and all the members. Thank you. Bye-bye.
Okay, item number 30, 32 Poplar Avenue. Again, there's only one speaker, Mike Walchuk, the owner. So I won't bother summarizing this application because I believe we have a deferral request from the agent, in this case, to revise the FSI.
Good afternoon.
Mr.
Yeah,
Walchuk,
good afternoon, Mr. Chairman. Yep.
How are you?
Good, thank you. Yes, you're correct. We're gonna elect to defer this. We're gonna go back and work with the planning department to bring that FSI into something that's a little bit more mutually agreed upon.
Okay. Yeah, because you have 7 variances for a detached dwelling, attached garage. We have your submission, transportation, and you're, I guess, going from 0.5 to permitted to 0.77. Is that correct? 0.71.
0.71.
I can't read my own.
Yeah.
Okay.
Yeah.
Okay, so you realize you won't be back before the committee until the new year, sometime in the spring, likely?
Unfortunately, yes, I realize that's the reality here.
Yep. Yeah, because planning, I guess, was of the opinion that this matter, hold on. No, sorry, that's on item 31. I went the wrong one. We don't have anything from planning. But planning has.
When I'd spoken with them, they had let me know they had submitted something, but I don't know for sure.
Yeah, he says they've asked me to make some concessions to term of FSI. I must request we defer in order to accommodate time for us to review and amend the proposed build. But they never did give us a report. In any event.
Gotcha.
Okay, so on the matter of the deferral, I'm ready for a motion. Anyone have any further questions for the owner?
Mr. Chair, I'll move for deferral to enable consultation with the planning department and revisions to the variances.
Okay, thank you, Mr. Taylor. Seconder, Ms. Alderson. All in favor? Okay, matters deferred. And Happy New Year to you. We'll see you here in the new year.
Thank you. You as well.
Okay. Okay, so next application is item number 31, 26 Wareside Road. And this is an application. We do have 2 speakers on this application, both the agent Graham Barrett as well as the neighbor at 31 Groverdale Road. This is an application to convert the property to a duplex and construct a partial second-story addition, maintain the existing west side ancillary structure. Planning has no objection. We have 4 variances and a planning report for information. We have 2 letters of support, 2 letters of opposition, and we have a transportation memo, which I had a note here was not very clear. I think it's just for information. So let's hear from Mr. Barrett.
Good afternoon, committee members. Good afternoon. How are you?
Okay.
Good. Yes, as you mentioned, this is Graham Barrett of 1575 Dundas West. I'm the agent for the owners of 26 Wareside Road. Here to request 4 variances from the zoning bylaw in order to permit a duplex via a second-story addition. This will create a separate living space for a family member within the home with access via a staircase on the west side. We're also seeking to legalize the existing accessory structure, as you mentioned. We have approached several neighbors, and we actually have 3 letters of support, although one of them came in just the other day. So that's 22 Wareside, 28 Wareside, and 30 Wareside. The one for 28 was submitted to staff, but it was past the deadline. So these are the 2 homes to the east and the one to the west. I have read the staff report, and I appreciate their comments. The reason this is being considered a duplex is because it will be a building that has 2 dwelling units with 1 unit entirely or partially above the other. whereas a secondary suite means a self-contained living accommodation for an additional person or persons living together as a single housekeeping unit located in and subordinate to a dwelling unit. So the proposal was reviewed as a duplex in determining the variances. However, planning staff have the opinion, and I agree, that this proposed second unit would function similarly to a secondary suite, and this proposal is in keeping with the existing character of the area. We appreciate that they have no objection to the proposal. None of the variances being requested actually pertain to the second story addition, which will be located within the existing building footprint. The home, as altered, will not exceed performance standards in any way, complying with the zoning bylaw in terms of height, floor space index, all setbacks, and so on. If this were simply a second story addition rather than a change of use to a duplex, I would only be here requesting variances pertaining to the existing shed. This type of intensification is also desirable from the perspective of the official plan, and this proposal is in keeping with its general intent. I am aware of the 2 letters of opposition which were sent in, and while I do sympathize with their concerns about privacy and sunlight, the fact remains that this addition could be built as of right if it were not being considered a duplex. If there were a separate basement secondary suite instead, the same would be true, and secondary suites are permitted in an RD zone. This proposal will have no other negative impacts on things like traffic or property taxes as suggested, but it will be one of the first second-story additions in the immediate area, which can be distressing for some. I'd be happy to go through all the variances one by one if you'd like, and answer any questions you have. But in conclusion, this proposal passes the 4 tests. We do have planning support and the support of 3 neighbors, including both adjacent. None of the variances actually have anything to do with the proposed structure, and it will be a tasteful and suitable addition. Thanks for your time.
Okay, thank you. So we have 2 letters, as you stated. We have the letter that you mentioned, property tax and those things. And then you have the other letter, which the speaker is here. That was a more fulsome letter with photos, 5-page letter from Danuta Winiars, who is with us. So we'll, if there's no questions at this point for Mr. Barrett, let's hear from the neighbor.
I have a question for staff.
Okay.
I just want to get my head around this duplex or versus secondary suite. I mean, if in fact this is just a secondary suite and not a duplex, then should we not amend the variances to reflect that and go forward accordingly?
No, sir. According to Toronto building staff and according to the definitions of the bylaw, this is a duplex. A duplex, as I said, means a building that has 2 dwelling units with 1 dwelling unit entirely or partially above the other. And a secondary suite means self-contained living accommodation for an additional person or persons, etc. I understand that the distinction is a little confusing to me as well, but in this case, the city is considering this a duplex and therefore variance is required.
But in the case of a duplex, wouldn't you need a second hydrometer? Wouldn't you need a whole lot of a second mailbox and all kinds of other standards?
That's all up to the owner because they can choose to pay the utilities.
I
It's
see.
not separately owned.
Okay.
It's rented out separately.
But my concern, and this is really to staff now as opposed to the applicant, is that if we're going to approve a duplex and this can be then converted to what will be a standard duplex as opposed to a secondary suite.
Well, zoning is considering this a duplex
Yeah.
because it's a purpose-built that way.
And as Mr. Barrett said, it's one over the other.
Yeah.
So it's part of the
it's-
definition.
Okay.
It's just
A
that,
secondary suite is ancillary. It's not supposed to be the same size as the main
Exactly.
unit. It has to be smaller.
Yep.
It has different requirements, and they're at least being honest. They want to build it as a
Mhm.
duplex. So
okay, so Mr. Barrett, let's hear from Ms. Winiars in relation to her letter, and you'll have a chance to respond.
Okay, thank you.
Welcome.
Good afternoon. Hello, yeah, thank you. So my name is Danuta Winiards. Thank you for providing me this opportunity to further express my serious concerns with this proposal. I have outlined a lot of information in the letter I submitted, but I would like to just highlight 3 key areas. And one being the impact on my privacy. So I have been here for almost 30 years. We've spent the last 30 years enjoying the quiet and private setting. We spend an inordinate amount of time in our backyard. We use our hot tub 12 months a year, so we're not using our backyard for only the summertime. Currently, we have a very private setting, although our patio is right next door to our neighbors. Their current structure is very low and we're separated by a privacy fence. So this allows for privacy of enjoyment for both myself and our neighbors. Allowing a staircase to overlook our private setting will have a detrimental impact on the enjoyment of our private space. The proposed two-story structure will result in zero privacy and the loss of enjoyment of our outdoor space and natural sunlight. The second part I'd like to highlight is the natural sunlight that I currently get from the southeast, and I thank you for sharing the pictures there. The side door, as you can see there, I have double French doors with a very large glass window, designed intentionally and positioned intentionally to capture all the natural sunlight. The sunlight currently penetrates through my side door well into my basement. It lights up half of my basement. And in addition, it lights up my entire hallway and the kitchen of my main floor. So 50% of my main living space comes from natural sunlight through most part of the day. My dining room window, which is positioned in a way that allows for an abundance of natural sunlight into my dining and living room, in addition to my kitchen, because I have an open concept. My dining room has been my office for the past 2 years while working from home. Mostly because of the natural sunlight that I get from that window. Overshadowing and loss of natural sunlight from my living room space will have a negative effect on my overall health and well-being. The reason I was allowed to work from home was due to the lack of natural light in my downtown office. So removing the ability for me to continue to enjoy all of the natural sunlight I've been enjoying, this will have a huge impact on my ability to continue to work from home. And the lack of natural sunlight will definitely impact my health and well-being. Lastly, I would like to say that the current neighborhood, so we live in a current neighborhood that is a mature single dwelling family community. There's no duplexes, there's no multifamily dwellings in the immediate area. Multiple families using space, outdoor space that's designed for one family will compromise the peaceful enjoyment of neighboring properties. And although the current intention may be to accommodate a family member, the reality is that it will become a rental property at some point, given the separate entrance and given all of the amenities that exist in the proposed unit. So if we start to allow to convert homes to multifamily homes, it will have a negative impact on our entire neighborhood. There will be more traffic, there'll be more people, there'll be more noise, not to mention the construction noise, which will be irritating, as many people work from home in the area due to the pandemic, and in addition to noise disruptions for neighbors. This will have negative implications, more pollution, toxins in the air resulting from the construction, and will probably have an impact on the property value. We will require increased services, waste collection, education, which will impact the city. And to conclude a little bit of that, I just strongly feel that it's simply not right, after living here for almost 30 years, for our neighborhood, for our neighbors to propose a large two-story structure that will affect my privacy, health, and well-being. It will completely remove all of the natural sunlight that I've enjoyed for the past 30 years. I would like to continue to enjoy. And the look of our lovely single-family community will be ruined by introducing a negative trend to this neighborhood. This will have a huge negative impact on my quality of life. I have been a hardworking woman for the past 35 plus years, raising 3 kids on my own. I was looking forward to a retirement in a couple of years and was hoping to be able to enjoy my private space, my sunny space, and my peaceful yard without an obstructed view. I would like to further add that I oppose the request for 1 parking spot. Self-sustained unit, one can reasonably assume that some point in the future.
Sorry, can you try to wrap up because you're over 5 minutes?
Okay.
Thank you.
I was just going to say that in summary, I also oppose the request for 1 parking spot when this is clearly going to be a rental unit at some point. It'll create additional street parking, friends and visiting parking on the streets, have issues with snow plows. Tenants tend to be messy. It'll distort the look and feel of the neighborhood. In addition, just quickly, I also opposed the structure in the front. Having a shed in the front yard is simply not acceptable. It looks messy, it looks junky, it's an eyesore, and there's not one property in the area that has a shed in their front lawn.
Okay, thank you,
Thank
Ms.
you.
Winiars. You're aware, you've seen the planning report? Have you seen the planning? What
Yes.
Planning, so basically planning is saying they were reviewed, as we heard earlier, as a duplex in determining the variances, and they're saying, however, planning staff of the opinion proposed second unit would function similar to a secondary suite, and the proposal is in keeping with the existing character of the area. So they just don't see a difference between a duplex and a secondary suite. It's technically a duplex, but everyone is as a right, you, them, any other neighbors, to have a secondary suite, which is subordinate to the main suite. Here, because they're a duplex and they're both equal, it's a different performance standard. But planning is not giving us recommending, they're giving us this report for information, and they're saying it's similar to a secondary suite. So anyway, that's, let's go back to Mr. Barrett to respond to your concerns. And then in the meantime, do anyone have any questions for the neighbor, Mrs. Winiars? She is at 26. No, sorry, she's at 31 Groverdale. Okay. Mr. Barrett?
Sure. Thank you. Well, I do sympathize. I'm sorry, go ahead.
No, I'm saying you were saying you could build this as of right if it wasn't considered a duplex and it was a secondary suite. And
That is correct.
And effectively, there's no difference.
Yeah, so we do appreciate their position on that. And I do sympathize with the neighbors' concerns. I mean, it can be difficult living in an area where people are building additions. And I mean, I understand that I'm in the middle of one myself. But as for concerns about privacy and noise and so on like that, this home could be built bigger if they wanted to. I believe the maximum height is 9.5 meters and proposed is 7.45. We're well below in terms of GFA and coverage. They could conceivably build a much larger addition, impacting privacy if they so chose. Concerns about the staircase access and privacy. I mean, there's no variance for this, but it's not a deck. This is not a sitting area. This is simply an entry point. Concerns about sunlight are not exactly a matter for committee, but I do sympathize. As for multifamily dwellings, secondary suites are allowed as of right. Whether or not this becomes a rental for somebody outside of the family at some point, the owners could be well within their rights to do that, and the behavior of tenants in general is not really in question here. Other concerns about pollution, noise, and so on are not particularly relevant. Parking concerns, there is a variance saying we're only providing one spot, and I'm not 100% clear on why that's been triggered, because there is a single car garage, and there is room for 3 other cars in the lot, in the parking driveway, without impeding the sidewalk. I mean, when I went by and posted the sign, that was the parking situation. So 4 cars can be parked comfortably. There won't be additional strain on street parking. This really isn't an issue. And as well, the shed being in the front yard, this is a corner lot, so the side yard is considered the front yard. So this shed is actually in the side yard rather than the front yard. And I believe that addresses all the points raised by the neighbor.
Okay, so again,
yeah, it's a corner lot.
Yeah, so the transportation memo, this is one I was talking about earlier today. There were a few today that look very confusing, that it just basically states what the park transportation variance is, and they just say you're deficient in one spot, but they don't say they're okay with it. They don't say they're against it. It's just sort of like I would say the equivalent of a planning report that's given for information, because they don't have any, Madam Treasurer, they don't have any conclusion at the end of their memo. This transportation memo in this one, they just sort of acknowledge what it is and don't say anything. So, okay, so I appreciate what you're saying, that they could build something bigger, that it's only technically or it's a duplex. If it wasn't a duplex, it could be a secondary suite as of right. You mentioned the privacy concerns. Is there something that could be, the concern seems to be from the stairwell looking out over their rear yard. I don't know, it's not like if it was a 2nd story balcony, we could say, okay, you put up privacy screening, but this is an internal staircase that they're talking about. So I guess there's really nothing that can be done.
No, it's exterior.
It's
It's on the side of the house. It's an outdoor.
So again,
Yes.
I don't, you know,
I mean, if a bit of privacy screening on that would help, I'm sure they'd be open to that.
anyway, perhaps that's something can be discussed for, you know, mutual neighborly, just, you know, the situation is when someone's in a situation for 30 years and there's a change, even if the change is as of right, there's an impact on someone who's enjoyed something for 30 years. That's going to change. So it's sort of human nature, and I agree. I sympathize with the neighbor as well. So committee members, anyone have any questions for Mr. Barrett or for Ms. Winiarz to follow up as in conclusion, or do we take it into committee for a motion and a decision?
I just want to voice a concern. It's not really a question. I think the application as it stands, if it were for a secondary suite, I think there'd be no issue. My concern is the fact that what we're approving is a duplex in a zoning that duplexes are not allowed. And I believe planning has taken the wrong approach for that reason. And for that reason, I'll be opposed to this application.
Yeah, planning's position is they're okay with it, though. I think.
Yeah, they're okay with it.
Yeah.
But essentially what they're doing is they're allowing a duplex in a
Correct.
zoning that doesn't allow for duplexes, which doesn't make sense to me.
And in reference, Mr. Barrett did say that you could build a single family or a secondary suite and have built a much larger.
And I would propose that
Yeah.
that's what should be done. I'm not opposed to the physical. I'm not opposed to the massing. I'm not opposed to the
Right,
physical
privacy,
character.
yeah.
None of that. I'm opposed to the planning precedent that's being set here, which I believe is unnecessary because we zone for properties. We don't zone for people.
Correct. That's correct. And you know, although the city is in favor of increasing the housing stock by having secondary suites, not necessarily a duplex, because you're saying it's not the character of the neighborhood. But we agree that whatever the impact is on the neighbor would be the same or even worse if they just made sold a lot to have a big single family. Yeah. Okay. Okay. Thank you. Okay. Any other comments or reflections or questions for the parties before us, or is someone ready to make a motion?
If no one else will, then based on my comments, I will move a motion to refuse.
Okay, thank you, Mr. Kamarick. Do we have a seconder for that motion? Going, no seconder?
No.
Okay, the motion fails. Do I have another motion?
You know, I think the whole secondary suite versus duplex verbiage is, I think we're arguing semantics here. I think that the outcome will basically be the same either way. So I'm going to put forward a motion to approve the variances as they stand. I believe they're minor in nature and desirable, and in terms of conditions, community planning has no objections. So, you know, I think, yeah, I'm good with that.
Okay, thank you, Ms. Alderson. There is no urban forestry on this one. Second
No.
for that motion.
I'll second, Mr. Chair.
Okay, thank you. All in favor? Motion carries 3-1. Thank you. Thank you, Ms.
Thank you very much.
And thank you, Ms. Winiarz. Okay, item number 32 is 3 Victoria Boulevard. It's an application to maintain the existing detached garage. There are 4 variances, and there's absolutely no comments by neighbors or by city departments. The speaker is Andre Grisolia, the agent for the owner. Good afternoon, sir.
Good afternoon. My name is Andre Grisolia of 8 Freemet Crescent in Toronto.
Okay.
I'm the authorized agent for the owners of 3 Victoria Boulevard, which
thank
have
you.
the 4 variants. Yeah.
Okay, I don't think we need a presentation. You have 4 variances. It's a what's the maintained situation? What happened? Was this built without a permit, or what happened here?
Exactly. It was built without a permit, which has minor variances before you.
Okay. Okay, committee members, any questions for the agent, or is someone ready to bring a motion? The variances look rather minor in terms of the percentages of soft landscaping and the north-south and the coverage. It looks pretty minor, and there's no comments from any city departments or neighbors.
Mr. Chair, I find the requested variances to meet the 4 tests under the Planning Act, and I move for approval without conditions.
Thank you, Mr. Taylor. Seconder for that.
I can second that.
Thank you, Ms. Olson. All in favor? Unanimous approval. Thank you, Mr. Gasolia.
Thank you.
Okay. Next application is item number 3310 Dunedin Drive. This is an application to construct a 1-story rear addition and a covered rear flat platform. There are 3 variances. We have a site-specific zoning bylaw. We have planning requesting a condition of approval, being that the property will be built in accordance with the site plan dated September 26, 2020. And that's all we have. The speaker on this is Stephen Lindy, the agent.
Good afternoon.
Good afternoon, Mr. Lindy. Very straightforward application. You're aware
Good
of the
afternoon,
staff condition?
Chair and members committee.
Okay. I don't know if you'd like to add anything. You're okay with the staff condition that it be built in accordance with the site plan?
Yes.
Okay. Would you like to add anything, bring anything else to the attention of the committee members? Or I'll just see if they have any questions for you or ready to bring a motion. Nothing to
If they have
add?
any questions, go ahead.
Okay, any questions? Or if not, is someone ready to make a motion?
Mr. Chair, I believe the requested variances are minor in nature and meet the other tests under the Planning Act as well, so I recommend approval subject to the condition required by the Planning Department.
Thank you, Mr. Taylor.
I'll second.
Mr. Kamarek, thank you. All in favor? Unanimous approval. Thank you.
Thank you.
Okay. Our final application of the afternoon is 37 Kings Garden Road. It's an application for a detached dwelling with an attached garage. As we have a covering letter from the agent. We have supplemental material. We have planning and support. There was a modification of the variances. So we have the zoning waiver and revised plans dated November 20th. And we have 3 letters of support, 2 letters of opposition. And the revisions are, the planning is supporting based on the revisions made with the agreement of the applicant as set out in the planning memo. They're asking for these modifications, variances 1, 2, 4, 5, and 6. So the question is, I believe these have already been reflected in plan, but we'll hear that from Mr. Romano. And in addition to Mr. Romano, we have 2 other speakers, the neighbors at 39 and 41 Kings Garden Road. Hello, Mr. Romano.
Good afternoon, sir. I will just note one thing, that variance number 4 is not the one to be altered. It should be variance number 3. So it's the subject matter is the same, but variance number 3 is the one that deals with the side yard setback for the building.
So the third point of their memo, which says staff recommend variances 1, 2, 4, 5, and 6 be modified. It should be 1, 2, 3, 5, and 6?
Correct, yes.
Since the committee does not have the full list, Franco, could you go through the variances and tell us what you're revising so it's for the record?
Yep. So I'm going to go through the public hearing notice that I have.
Yeah.
Should we go that, or should we correct the recommendations set out in the planning? I guess it's either or.
Well, it should be what he's revising.
Okay,
it to.
that's fine.
So variance number 1 is being revised. The lot coverage is now proposed at 39.4%. And that is 196.3 square meters.
Okay.
Variance number 2 has some convoluted wording, but the gross floor area is 150 square meters plus 50.8% of the lot area. Parentheses 403.43 square meters and a floor space index of 0.8091.
Sorry. This is variance number 2?
It's 80.91%.
So how many square meters?
So that is 403.43 square meters.
Oh,
Do you have that reversed? Should it be the 150 plus the 80?
No, I had discussed this with Angelica about the numbers, the percentages. So that's why the 80.91% is the FSI.
So our notice was incorrect.
so is that higher than the notice went out?
It
If it's
is.
higher than
It
the
is
notice,
not.
Don't we have a notification issue? It's going up or down?
No, because the 88.88% is what is the alteration, and that's what the 80.91% is.
So 80.91 is less than 88.88, right?
Right, and that's
But yours-
403.
But what's your floor space index? On our notice, it says 0.58.
Right, and I calculate the floor space index to be 0.8091.
But Franco, you're at 0.58 at 443.17 square meters. If you're higher than
I
that,
know, I raised this with Angelica
yeah,
as soon as the notice was sent to me, and she said that she had talked to Miss Bartasek, and that the actual GFA of 443.17 square meters was correct. So if you look at the 0.58, next to that it says in parentheses 443.17.
yeah.
That is in fact what was proposed. So that number is correct.
The 443.17 is correct, but the 0.58 is wrong.
So what I'm
And it's
asking you, did she switch
0.58.
the numbers?
Yeah.
The 0.58 is to be flipped with the 88.88. That's in the same sentence.
I'm really confused now.
The 0.58 that's in that sentence
Yes.
should be swapped out with the 88.88% that's in the same sentence.
And where does what goes in place of the 88.88? The 0.58? Has that just been inverted? So reading the sentence, Franco, just hold on. The new dwelling, including the attached garage, will have a gross floor area of 150 meters squared plus, instead of 88.88, you're saying it's 0.58%?
No, 50.8. He's reducing it.
50.8. Okay.
Yep.
Which is 443.17.
403.43.
Okay, so that's lower. And a floor space index of, instead of 0.58,
0.81.
0.81, and 443.17, that's the correct number?
No, it goes to 403.43.
Okay, so that's going down.
Yes.
The 0.58 is wrong, and that is actually going up. But the question is that a notification problem? Because you had the 443.17 correct. The question is, would the public be, would someone, we do have the two neighbors here objecting in any event. The question is this proper notice or not? Because the 443.17 is right, but the 0.58 is wrong. And it's low. Right? So.
That's right, because the 5.8, the 5.8 and the 88.88% in that same sentence
Yes.
should be flipped.
So why didn't, that wasn't caught? And so,
Yep.
Madam
Well,
Secretary
I
Treasurer,
caught it and
Franco Romano.
I caught it and, I'm sorry?
I'm saying, so the question is, we have to determine whether we have a notification issue here or not before we proceed further.
Right. Well, it was my understanding when the notice went out that that notification issue was accepted because the actual GFA is correct and the numbers were on there. They were just flipped out. And I had asked if revised notice could go out, and they said that they had time to send out revised notice, but then a determination was made that the notice does not have to go back out because the actual GFA number is correct.
Okay, what about the rest of the variances? 2, 3,
So variance
3,
number
4, 5,
3.
6, and 7, and 8. Yeah.
Variance number 3, the
Anything else?
the west side yard setback has been increased from 0.61 to 0.91 meters. So that's a
Yeah,
smaller.
both sides. Yeah.
Sorry, can you repeat? 0.61 changes to 0.91?
Yes, so they're
Correct.
east and
Yep.
west will be the same.
Yes. And then variance number 5 is the dwelling length. That changes to 18.97 meters. And then variance number 6, dwelling depth, that changes to 19.25 meters.
Okay.
So those are the changes that were reflected and discussed in the planning staff report.
Okay, and we do have 3 letters of support, 2 letters of opposition. We have 2 of the neighbors here. So the question is whether someone would have been misled by the fact that those numbers are inverted in variance number 2. If not, we can proceed. If it is a notification issue, then I guess we have an issue. But like I
There
said, we
is
have the people here before us. That's a
There is
mitigate.
another error in the notice because for the variance for gross floor area, the maximum permitted gross floor area, including the area of an attached or detached garage, is 150 square meters plus 25% of the lot area. In brackets, that should not be 249.3. It should be, based on the zoning review, 274.65. Because those two numbers would never end up being the same. And the 0.5 is the 249. Correct, Franco?
Mr. Romano?
I am looking at the zoning notice.
Okay.
274.65 square meters. Correct. Barb, I can flip you that email that Angelica told me that this issue was addressed and that notice is not to have to go out.
I'm not doubting you.
Because she had time to send out notice.
I said the neighbors are here. So it's, Mr. Romano, it's correct in the staff recommendation memo. It talks about variance 2, 88.88 to 80.91. So that's correct.
Correct. Yes.
And then variances 7 and 8 stay the same, correct?
Yes.
Yes.
So if a neighbor who's not here, we do have 2 neighbors here. If a neighbor wasn't here and they went into the data, this is correct if they read the staff report. So I'm not convinced that we have a definite notification issue here.
I'll leave that in the committee's hands. The notice does indicate the most restrictive permission, which is the 249.3. And the total gross floor area number is provided in parentheses. So the total proposed information is there. The calculation is incorrect.
You know, because people have weighed in, and in fact, what is Mr. Romano is coming back with is actually less than is, you know, there's been a number of modifications in response to staff. It appears that it was if there is a misunderstanding, it seems to be a staff mistake. So I don't think there's any, we have the people here before us. So if you weigh the issues, I think it would be a great, you know, in terms of the time delay that Mr. Romano's client would experience vis-a-vis the risk of a notification issue, since it is correct in the staff memo, and like you said, it was the more restrictive, and the number is there in brackets. And the people are here. If there was no one here, I think it would be a bigger issue. But the two neighbors on one side are both here, notwithstanding. So committee members,
hands. I mean, this is why in the speech you say that changes will not be considered, and maybe that's something to think about moving forward.
well, yeah, but these were changes that were made not at the hearing on the fly. These were changes that were done well in advance, and in order that even the staff could weigh in with a report saying they were okay with that. So I don't think this is the same as someone coming and showing up at the meeting and say, change this, change that. It's all covered off. We have the revised plans and the zoning waiver, so it's not the same as making revisions at the hearing, in my humble opinion. So committee members, I guess we need to come to whether we're going to proceed or whether we have a notification issue. So I guess, Madam Secretary, we need a memo to that, a motion to that effect.
However you decide, if you all want to proceed, just poll the members.
Yeah, I know. So I don't know what the other members feel. Start with Mr. Taylor. Okay. Mr. Merritt. Mrs. Alderson, you comfortable proceeding?
Yes, I am.
Okay. Okay, so having said we've now gone through all of that, so why don't we just hear from the neighbors and you'll have a chance to respond, or we'd like to add anything, Mr. Romano, before we move on? I can't remember at this point how far we went into your actual.
I don't think he had his full presentation.
I didn't go anywhere.
Okay, Mr. Romano, item number, let's pretend we're just getting started. So let's give us a brief presentation, and then we'll.
I'll give you an abbreviated version, yes, sir. If staff can pull up my presentation sheet, please.
Sorry, Franco, I'm a little bit frozen, so I gotta scroll down.
Yeah, I understand. No worries.
There we go.
This is your,
Thank you.
Your letter dated November the 18th, and then the plans below that. Yeah.
Right. So this is a property located on the south side of Kings Garden Road. It's about 3 properties east of Prince Edward Drive North. It's a neighborhood that's under considerable renovation, new construction, regeneration. There's some examples of 3-story dwellings, new and older, in the lower right-hand side of my graphic presentation there. And you'll see in the air photograph in the upper right that building lengths and depths do vary in size, with a fairly strong front wall alignment along the street. The proposal is a new build, so it's to replace the existing with a new dwelling that's 2.5 stories. The 3rd floor is built within the roof line, within dormers, and it does have a modern, a recent architectural style that is Georgian in nature. Central hall plan, pane windows, dormers, hip roof with sloped roof. You'll see on the site plan that the dwelling does overlap the existing dwelling, although the existing dwelling is a little bit flag-shaped, whereas the proposed dwelling is more rectangular. The building length and depth reflect the 1-story rear portion that juts out, that little jut out at the bottom of the building envelope. And if you look on the lower left-hand side, this is the west side elevation. So this is facing number 39 King's Garden. You'll see that the side wall is 0.91 meters, and then there is a central staircase. Well, it's off center, it's a little closer towards the front. That is at 1.21 meters. So that 1.21 meters actually coincides with the tree protection zone for the neighbor who has mentioned their tree that is tucked in beside their dwelling. So that was done intentionally. And then you'll see to the right, the one-story addition, or not addition, but the one-story bump out to the rear, that has a 1.65 meter side yard setback. And then beneath that west side elevation, I have the numbers corresponding to the length and depth. 16.54 meters is the length of the building at both the first floor and the second floor, and you'll see that the roof line is less than that. So that's all less than the 17 meters that's permitted. The 18.97 meter length is from the front wall to the rear of that one-story portion at the back. And the 19.25 meter depth is taken from a point just in front of the building, because the zone examiner is calculating front yard setback a little differently, to the rear wall of that one-story portion at the back. So it is an articulated, well thought out design that fits within the building length. In terms of the side yard setback on the west side, you'll see the 0.91 basically overlaps what is currently 0.76 to 0.95 meters. And so the building on the west side is virtually over top of where the existing side yard setback is. It is a little bit longer because you'll see towards the south, the two-story portion, and then the one-story portion that is beyond at 1.65 meters. So there is tree protection. There's in terms of the regeneration that's occurring in the neighborhood, lot coverage, the floor space index, the side yards, and the variation in lengths and depths are quite commonly found, not only on King's Garden, but on other streets. So it is a fairly sympathetic design, in my opinion. And the neighbor to the east, so on the right-hand side of the site plan, is actually one of the persons that wrote in support of the proposal. Subject to any questions, sir? I submit that the proposal does indeed respect and reinforce the neighborhood character and has no unacceptable adverse impacts.
Okay, Mr. Romano, just as I'm reading through these, all the changes you've gone through, so would just be in the event of an approval, before we hear from the neighbors, is this an appropriate case for it to be tied to the plans, or at least the site plan?
Yes, sir, in my opinion. I think the site plan and the elevations, because the elevations do show the Georgian character, the dormers, and the fact that the third floor is basically where the additional GFA comes into play. It's in the attic, so that would reflect if you tie it to the site plan and the elevations, that would be the best approach, I believe.
Okay, thank you. Okay, so the next speaker is Lana Sturmack at 39 King's Garden. So that's right next door.
Okay.
I guess we have the letter of support from the neighbor on the other side of 35, correct? And you're at 39 on the other side. Welcome.
I'm at, yes,
I believe
I'm
we
at
have
39.
your letter, or no, we have the MacArthur's letter. And
You have, well,
okay, let us know what your concerns are. We understand your
excuse me. Yes, thank you very much. I want to just say at the beginning, I guess we're not being polled about having this adjourned, because I find it very difficult to follow what you were doing at the very beginning in these recalculations, and admitting that there's a calculation error in the notices that was sent to us. These were all documents that, I meticulously went through. I found it very difficult to follow all this and all the changes that were made. And now to, you know, have to deal with an error in the notification. I would just like some more time to reevaluate all this.
Well, I guess you did, both you and the other neighbor did have enough information to write very fulsome, complete letters of objection. So the issue is whether there's been any issues relating to the fact of the notice and having, as you heard, a committee went through it after some deliberation. The feeling was that there was no notification issue, that this matter is properly before the committee, and that the again, you and the neighbor are here, notwithstanding. So why don't you
Anyway,
we have your we have your letter, we have the other neighbor's letter.
Okay, yes, I understand that.
I don't think there's anything that's sort of missing, but so to have an adjournment for given that everything is sort of before it, is an issue. So why don't you let us just we have your letters, we've read your letter and the MacArthur letter. Why don't you just give us a brief summary of what your concerns are?
Yeah, so basically we feel that we're right next door to the proposed property, which is very, very large in comparison to this end of the street. I'm not sure that I agree that it really fits into the characteristics of the neighborhood in that area. However, the size of the property, I think very negatively impacts us. It reduces separation, privacy, sunlight, etc., everything into the enjoyment of our property. In particular, I'm concerned about the west side yard setback, which is supposed to be 1.2 meters. And I just heard the presenter talk about that the proposed building is going to be in the footprint of the existing one. I didn't find that's correct when I looked at the plans. That the existing property has some butt outs, which are probably chimneys. I'm not sure what they are, but it's actually not the same distance that I just heard presented. So we would expect that the minimum bylaw of 1.2 meters be respected, so that we would have some greater access to light and separation and privacy when we enter our yard at that side.
Okay, just if I could just interrupt, he did say that he's increasing it from 0.61 to 0.91 to be consistent with the east side, which is less than the 1.2.
I've seen that, and I addressed that in my letter. I've seen the 0.91, but the bylaw is 1.2 meters.
Correct. I don't know.
Yes,
Do you know if you have 1.2 on your side? Do you have 1.2 meters on your side, on that side, or I don't know if you know what?
No. The existing, yes. Well, existing property has some butt outs, and if you measure from the butt out versus the actual property, I think there's a difference. But regardless of that, the bylaw is 1.2 meters, and we would need that space because of the size of the proposed structure, leading into our yard.
Okay,
the second one is...
Sorry, but before we move on, I just want to clarify. We'll get Mr. Romano. He may know. I was asking you don't know if you have 1.2 on your side, which would be a total of 2.4. So Mr. Romano may have the statistics from the survey to let us know. So please go on. I'm sorry for interrupting, but he'll be able to tell us what your side yard is. Correct? I know you're not, you have an existing house.
I'm not, yeah.
Yeah, he's the one who's building a new house.
I mean, I'm not talking about my side yard. I'm talking about 37 Kings
I
Garden
understand,
side.
but I'm saying when you evaluate whether there's enough room and enough spatial separation between the houses, we look at what you're providing and what he is providing currently and what he's going to provide now with his proposed new house. I'm just telling you how the committee looks at it. We have to look to see if there's enough room between the houses. If it turns out you're right on the property line, which I'm sure you're not.
No, I'm not.
Okay, sorry for interrupting.
The second area is the proposed gross floor area, which is again, you've just indicated to us that there's a recalculation of that in the notice. So, I'm just noting that this is going to, significantly overlook my property and really make a very significant and negative change in the privacy and use of our property with the overlook into our house. This is our second objection, and our third was really about the tree, which I understand you've got the setback there, but I just don't know whether the urban forestry conditions apply to my property or to trees on 37 Kings Garden property. I didn't know, and I would want that, you know, evaluated by, you know, the forestry personnel.
Okay, Mr. Romano will respond to that as to what's happening with the trees. So that's your third concern. So those are your three concerns. Okay.
Yes.
Does anyone have any questions for the speaker, Ms. Sturmack? She's right next door.
Just a clarification, I'm looking at a survey and ma'am, your house, the east side yard for your house is 0.97 meters, just for information.
So it's slightly more than he's proposing at 0.91. So total would be 0.91 plus 0.97 for 18 or whatever.
Well, you know,
you have 2 inches more than he's proposing, your side yard. So it'll be very consistent with what you have. And the spatial separation will be equal to yours.
We're looking at variances from the bylaws, not from my property, right? I mean, isn't that what the issue is?
Yes, but you're
It's not about my property, is it?
Well, in part, if you were looking at you're complaining that their house is too close, and I'm trying to determine what the spatial separation, both which you'd add up your side yard and his side yard, to show how far apart the houses are, right? So it is relevant to. I know you're not making any changes to your house, but it's relevant to what you have currently to what, and that's why he's also showing us how the proposed new house relates to what the current house is. He's shown us the outline to make it easy.
But what does the bylaw refer to? What is the 1.2 meters refer to?
Under the bylaw, you're supposed to have 1.2 and he's supposed to have 1.2 for a total of 2.4. In fact, you have 0.97 and he's proposing 0.91. So it's not a big, it is a variance, but that's what it is. So we'll let Mr. Romano respond, but I'm just saying it was important. I'm happy that Mr. Taylor looked that up to let us know what your side yard is on that side, because that affects how you're affected. Right? If you were much closer, if your house happened to be very much closer, then the two houses would be closer. So it is relevant. Okay, so we have your 3 concerns. You'd like to add anything, or we'll move on to the next speaker?
Thank you.
Okay, so you've told us about your 3 issues, right? And so we'll have Mr. Romano respond to your concerns. And now we'll hear from Mr. MacArthur, who is your next door neighbor on the other side, 41 Kings Garden. And we have Mr. MacArthur's letter as well.
Thank you very much. This is Mr. MacArthur, and like you mentioned, at 41 Kings Garden, located 2 doors to the west of the property that's asking for the application. You have my letter, but I would like to highlight a couple of key things here. All of the homes in the Kingsway Park area, which includes the 70-plus homes on Kings Garden Road, were originally built back in the late 30s and early 40s. The homeowners have gone to great lengths over the decades to maintain their architecture, appearance, and charm of the neighborhood by being very thoughtful about renovations, both interior and exterior. In fact, there was a document prepared by the City of Toronto that outlines the Kingsway Park Heritage Conservation District guidelines that I attached to our notice of objection.
Yes.
That spells out exactly how homes are to be maintained, or if modified, how they are to be modified from an exterior perspective, specifically to retain the charm and character of the neighborhood.
Okay, can I just interject for a second? I'm just asking, what you have attached says draft Kingsway Park Heritage with all these nice fonts. Has this actually been put into force, and when was this done? Like, we know we have in Long Branch, we have guidelines, we have, different heritage districts. Has this actually been passed? Because I just see at the top it does say draft.
So I do understand that this was put into place. We are relatively new homeowners in the area, having moved in last summer, so not summer of 2020, but summer of 2019. And we were provided with this document from a number of sources, the realtor, the previous owner, as well as through our lawyers that prepared the document. So the understanding is that this document is meant to be something that provides guidance to all of the homes in this neighborhood.
Madam Secretary Treasurer,
What it
you
would-
know, I'm just saying, have you ever seen this document before? I've never seen it.
Never.
Okay. How long have you been the
Okay,
Secretary
you see, it
Treasurer?
is prepared by the city of Toronto.
Yeah, I've
Yep.
never seen
Got
this.
the
The
stamp
Secretary
on the
Treasurer's
bottom.
never seen it. So in any event, I don't know what the status of this, because it does say draft.
Well,
You've seen it? Oh, okay,
I
Mr.
would
Taylor is,
certainly-
Mr. Taylor has seen this before.
Okay, well, I would certainly ask that staff, since they have not seen this before, I would ask that as part of this application for variance, staff be given the affordable time to search out the source of this document and understand how it applies to this application. If they've not seen it, they've clearly not looked at it, and they've not given it any consideration, and I would like that to be included as part of the application review process, please.
Okay, we'll see if Mr. Franco has any notes, because again, we can't, this is a document that's marked draft, and the Secretary Treasurer's never seen it. Mr. Taylor, who's lived in, has seen it, but I don't know if you know, is this a binding doc, is this binding on anyone, or is it guidelines, or, I don't know. Anyway, can you just,
I think given you're
please
saying nobody
continue.
has experience with it, we should at least understand where it came from and what it's all about. Because it spent a great deal of time speaking about the character of the neighborhood and the requirements for all homes in this neighborhood to retain that visual appearance and the charm of the area.
Okay, well, I don't believe it's a binding document. But please continue with your,
Okay.
with your
So would you
objections.
please note our request to determine if it is a binding document as opposed to just opinions of people without looking it up? Can you acknowledge that for us, please?
Sorry, I'm just listening to your presentation, and Mr. Romano is going to respond. And
Sorry, I'm just asking.
I'm not
if
agreeing. I
the
can't agree
review
to anything
committee-
here. Okay, just please make your presentation.
Yes, will the review committee please acknowledge they will look up this document and determine its applicability in this instance?
No. Madam Secretary Treasurer?
It's not up to the committee to source information and determine validity. The committee has the information, they've read everything on file, and they'll obviously consider everything that's before them. But they do not do their own research to look up information on whether this should be considered or not. It's before them, they've read it, it will form part of the minutes and part of their decision.
Okay, well, I have taken the effort to provide the document, believing it to be true. So if I will move on, certainly the vast majority of the homes in Kings Garden Road have preserved their 80-year-old character and their architecture. And I think even the bylaws that we're talking about being reviewed today speak to that in order to maintain the character of the neighborhood. These are site-specific zoning that are meant and with a lot of thoughtful consideration put in writing to make sure that the homes in the area stay of a certain nature. And when I look at the requests for the variance, there are very significant changes. And I know we've spent a lot of time talking about this gross floor area piece, whether it was misleading, misunderstanding, whatever. We're done that conversation, but I have to highlight this. The bottom line is the bylaw states the maximum floor space index should be no more than 0.5. This application, though reduced from 0.88, is still 0.89 or 0.81. It is more than 60% over the bylaw requirement. That is not a minor variance, that's a major variance. I'll carry on with the height limitation, though not addressed in the staff report. It is quite shocking that it wasn't, because this is a dwelling that is asking to be more than 50% higher than the bylaw. Flat roof dwellings capped at 6.5 meters. This application's for 9.5 meters. That it makes it the largest home on the block, and it will be an outlier and absolutely, unfortunately, become an eyesore to the rest of the neighborhood and drag down the character of the neighborhood that has worked for 80 years to maintain it. The zoning bylaws, like I say, were carefully written to prevent such radical changes to the buildings in our community. People live here because they want to live in an area that looks like an old established neighborhood as opposed to a new subdivision. This new house design with its size and its variations looks more like a subdivision. We want the Committee of Adjustment to reject the excessive request and bring it back to something that looks more like a minor variance as opposed to the major one that asks for more than 60% square footage above the bylaws and 50% height above the bylaws. It's a special neighborhood in Toronto. We need the government to help maintain this highly sought after area. Don't let the 80 years of history get chipped away by constantly allowing these deviations to the bylaws. Listen, we do support a new home design. However, we support one that complies with the Heritage Conservation Guidelines, which we spoke of earlier, but in particular complies with all of the bylaws that are in place. And like I say, those bylaws were written for a reason to maintain the characteristics of this gorgeous 80-year-old neighborhood. So a slightly smaller design, one that looks like it blends in with the existing 80-year-old neighborhood, is important. As much as Mr. Romano would say he believes it blends in with the neighborhood, I can absolutely state it does not. It is nowhere close to any other home on Kings Garden Road. So please do not accept these adjustments, even though the staff report looked at a couple of items. I believe there are more items to be looked at, specifically the 60% overage in square footage and the 50% overage in height, to bring this home back to reflective of the neighborhood and the architecture style and character that people have worked decades to maintain here.
Okay, I'll just point out, and I agree, you know, we deal with the variances, and you're right, these variances, we don't strictly go by numerical, that's one thing, but in terms of the architectural style and the character, we have no jurisdiction over that. And I agree, this is a beautiful, and people have maintained that character, you know, from old world character from 80 years ago to make it modern, but yet still fit in. But we have no authority over that. We are not the design police. We deal with the variances, and I do agree that the variances are, at least on a numerical basis, appear, you know, high, but that's what we look at. We can't comment on if someone wants to bring a house. These guidelines, whether they're guidelines or not binding, or we don't even, they're marked drafts, so that's sort of an open issue. So anyway, thank you for your, you know, I appreciate this is very important to the neighbors and very important to you, and we thank you for your reasoned objections. And with Mr. Romano,
thank you. I do understand you can't comment on the style of the architecture, understood, no. But please make sure there's adherence to the bylaws. That is so critically important to the neighborhood.
Okay, thank you, sir. Okay, we'll go back to Mr. Romano. Mr. Romano, you've heard comments from the neighbors at 39 and 41. Please respond and to those comments.
Yeah, so start off with building height. So the building height that is a variance here is the Etobicoke zoning bylaw building height. And that differs in terms of how it calculates height as compared to the 2013 zoning bylaw, the harmonized bylaw. The property actually complies with, the dwelling actually complies with both the main wall height and the overall height to zoning bylaw 569/2013. And you'll see that zoning bylaw 569/2013 referenced in other sections on the public hearing notice. So this is one of those situations where there's the old bylaw, the old Etobicoke bylaw dating back to the 50s, 60s, and 70s, and this 2013 bylaw that measures height differently. So the overall height actually is in compliance. And if we look at the height of the front elevation, and then we look at the dwelling that's on the photograph in the middle on the right-hand side, they are strikingly similar. So the first, second floor have floor heights around 9. I think the first floor is at 10 feet. The second floor is at 9 feet. And the third floor is fully within the roof. So those are in dormers, and that is at an 8-foot height. So that, if absent the floor area or habitable space in the roof, the floor space index is actually at 0.667. So that is the reason why the additional GFA or FSI is because a roof is being utilized as efficient space within as habitable space, but it's only at 8-foot ceilings. And I will say that if one looks at Mr. MacArthur's submission, those draft guidelines, on page 4 of that PDF, not sure if the guideline itself has got a page reference, but in the lower left-hand side, there is a dwelling that is shown with strikingly similar features to what is proposed. Right, page. So on the upper left-hand it's on the upper left-hand side, it says houses on interior lots. I know staff are trying to help me find it.
And Mr. Romano, as a professional planner, were you
Pretty-
aware of these
that's
draft
it, that's it,
guidelines?
right.
Have you ever seen these before? Are you aware of it or the status of it? Mr.
That's
Taylor.
that's the page right there, 1.1.1, right in the lower left-hand side. So this there are no heritage guidelines in this neighborhood. So there are none that are enforced. This is a draft document that I have seen before many years ago, but it's not being put into force or adopted by council. But if you look at the front elevation and that that lower left-hand photograph of Mr. MacArthur's submission, they are virtually identical. The main difference is that there is now an integral garage, because in today's standards under the zoning bylaw, one has to have parking behind the front wall instead of a window. But otherwise, there's fenestration on the first floor, pedestrian entrance on the first floor, second floor windows, pane windows, and dormers in the roof, where there's habitable space in the roof line. So the proposal is strikingly similar to that dwelling right there in the lower left-hand side. In terms of the building setbacks, side yard setbacks, this often comes up with zone examiners. The property today has an 11.68 meter lot frontage. The minimum required side yard setback for a lot that is less than 12 meters frontage is 0.9 meters. The zone examiner has identified 1.2 meters because the overlaid zoning category for this lot requires, I think it's a 13.5 meter frontage. So the zoning requires a larger frontage than what exists, even though the existing is compliant. And the side yard setback is proportionate to what is required for the lot. The zone examiner just identified it as a variance, but as the committee's already pointed out, the existing side yard setback on the lot ranges from 0.76 meters to 0.95 meters, or in 9.6. So the property on the west side overlaps that. I already mentioned the tree and how that tree is beside where the 1.2 meters is being provided. So that is to protect the tree and avoid injury to it. And the roof itself also slopes away from the sides. So there is no, so it moves away from the side lot lines. And on the west side, there is no eaves setback variance. So the eaves is farther away from the side lot line than is what is required. So that helps with sunlight penetration, etc. And there is, as I showed in that lower left-hand west side elevation, there are no windows facing to the west other than the staircase window. That 1.21 meter side yard setback component with the fenestration there, that's the staircase inside the building. So there is no overlook from any main living area or even a bedroom in that case. So subject to any questions, sir, I think the proposal does indeed address the architectural style, character of the area, has reasonable FSI based on its deployment and use of the roof. Even if that FSI was considered, you wanted to change the number, there would still be a roof there. So I don't believe that that has any impact. So subject to any questions, sir, I submit that the variances as revised should be approved, subject to being substantially in accordance with the site plan and the building elevations.
Thank you, Mr. Romano. Any further questions for Mr. Romano, or for either of the neighbors for that matter? Or is someone ready to, can we take it into committee for a decision? And have someone ready to weigh in with a motion? Not everyone at once.
You want to ponder for a bit, Stan? No. What? I could table something, but I don't want to push the agenda. Okay, after listening to the proponent and some of the neighbors for quite a while, it was quite a meaningful experience for us, I think, to hear all of the different perspectives. The way I settle on this is, I think it is a reasonable proposal for this neighborhood. I think it's quite compatible in size, scope, massing, scale with what's there, and would be quite in keeping with the neighborhood. So my motion would be to approve the application as revised, subject to urban forestry condition 2 and the planning conditions, which I guess are just basically the revisions.
So you don't need those.
Yeah.
The applicant has amended.
Okay.
Build substantially in accordance.
Oh, yes, and a condition that the construction be built in substantial compliance with the plans filed with the Committee of
How about the
Adjustment.
site plan and the elevations?
Okay, the plans, site plan and elevation drawings on file with the Committee of Adjustment
As revised, yeah.
as revised.
Okay, thank you for that motion, Mr. Taylor. Do we have a seconder for Mr. Taylor's motion?
I'll second that.
Mr. Mark, okay, all in favor? Opposed? All, you were unanimous? Laura, you were in favor? Okay, it's hard to see when the hand goes up. So we have a unanimous approval. Thank you, neighbors, and thank you, Mr. Romano.
So the date on those revised plans.
Thank you kindly.
November 20th, the ones the revised plans.
Correct.
Okay.
All the best of the season. Be well.
Thank you. Happy New Year. Merry Christmas. Okay, and we stand adjourned at
Thank you, everyone. Good night.
5:45. Good night, Laura. Happy New Year. Merry Christmas.
Yeah, same to you. Thank you.
Thank you.